little bit of correction, one to correct it, but don't give it out. Send it back. The judgment of the single judge is set aside. We appeals are allowed. I will bless you.
May I please, Your Lordship, firstly, I want to mention regarding listing of an IA. An IA is regarding correction in the cost title on Monday. Much of it.
Item number 9, the file an affidavit.
Madam, let's read on Tuesday. Madam, Tuesday. Monday, it'll be too much.
File an affidavit in opposition. Item number 9.
Item 9. Yes, what about it?
This may be the call for.
Item?
9.
Yes.
No, I am only saying for it. Okay. Started. I have got it all.
Okay, right, Mr. P. Nayak. The council submits that he would like to file affidavit in reply to the affidavit in opposition filed by
That's number 1.
the file number. Praise allowed. This is the matter on 8th.
On
8th. Huh?
On the we have to devote application of the admission.
Okay, please.
Right. Okay. Okay. May I please? Okay, by that mention WC 2596 listing on 2nd April.
Pending matter, no.
30.
No, we have two full. We have got full bench also.
I'm free for listing of two
After Bihu.
after this. 22nd. Because I'm free listing of two motion matters on Wednesday next week. Matter pertains to auction of two team states. Some of it. But is
But what is the
auction is we held on 9th. 9th of it.
I beg to mention for listing of a pending matter. A convenient date for the office.
after Bihu?
Madam. May please the Lord. I beg to mention item number 4, Lord. Better maybe can you address more than maybe taken next week any date. My schedule is not well.
Tell me item 4.
We have taken the consent also. Lordship.
Yeah, what is your name?
MS Mondal, Lordship.
Mr.
MS Mondal.
M.S. Mondal, learned counsel for the petitioner, feels that the matter may be adjourned, as the senior is not well. Accordingly, leave this matter after a week. What?
We have received the reports.
Okay, you have received the request. When do you want it?
Lordship, any date before the date.
But what is the record? Basically, the thing was that he had given it to some other persons to run the market.
Lordship, that's his case, but we have received the record today. But according to the officers there, they have said that he has not submitted the statement.
Oh,
That's why he has his present.
defaulter. Then
It may be taken up before it is made. I see.
both. This is a matter of both.
Deeply obliged, Lordship. Yes, please, Lordship. Lordship, I beg to mention item number 14. I have taken the consent from the other side also.
Item number 14.
14 of the day. But we are being led by Dr. Saraf and Dixon. Due to the part matter today, Dr. Saraf is appearing before Mizoram. But I'm on behalf of response.
After the vacation,
After the vacation.
on the prayer made on behalf of Dr. A. Sharaf.
Yes.
Then it passes for the petitioner. This is the matter after the vacation.
Eight.
No, hurry, 2019 matter. What is the hurry?
Also, the document like 15 and 16 of the date. Also, this is current office for FCI is out of state. We need some more time to.
Who is the standing counsel?
PK6.
BK?
PK6
BK6.
for FCI.
Okay, right. On the prayer for adjournment. Who's for the other side?
I'm for the
Any objection?
Lordship, I'm for the respondent 227. No objection, Lordship. I have no objection.
Okay. On the prayer. And what about the petitioner?
Petitioner in item number 15, I'm appearing for the petitioner.
Oh, you're for the petitioner.
Yes, yes.
Okay, right. On the prayer for adjournment made on behalf of Mr. BK6, Leonard and Leonard counsel for the FCI, which is not objected to by Mr.
He has right.
E. Hazari. This is the matter after the vacation.
Also, the date may be fixed.
That's it.
The first week of May,
Okay, good.
8, but 6. Lordship, I beg to mention for decree of a certified. It is 20 since the Lordship last December.
What is the matter about?
Matter Lordship, petitioner has bought a plot of land from the respondent Lordship, and the brother of the respondent has constructed some buildings upon the land and it has trespassed Lordship.
That is a matter for this court, for this bench.
Lordship, it was previously it was taken in money to the court Lordship. But
No, you see, it depends. I don't think this bench 4 is a bench 4 matter. It's a dispute between two brothers over land. It's a WPC.
yes, sir.
I think probably the bench 3 or bench 5 matter. I think. I don't know if you go to the registry. Tell them to.
Lordship, it is also item number 6, Lordship.
Huh?
Number 6.
Yes.
Lordship, I pray for the explanation. I'm really for it.
I'm for sure.
On the prayer for adjournment made by Ms.
Either.
Aida. Then counsel for the petitioner, which is not objected to by Mr.
I bought
I bought Thakur, Leonard counsel for
responded one.
the point number 1. This is the matter after.
The next week of only for today, I is that.
This is a contempt matter, madam.
Lordship, it is that those Lordship, that a speaking order has been passed. Lordship, if they can bring the same on record, Lordship.
Is there speaking order? Is it here with you? Then what? Why do you want to adjourn the matter? Here, give me that.
I'm just told, just now.
You're told rightly. So we'll just see. It's a contempt matter, madam. It's not between you and anybody. It's between the court and the contempt law.
Lordship, we don't have any instructions from the,
You don't have to have instructions, madam. It has nothing to do with you. It has something to do with the court and the alleged contempt law. That's all. Your only role here is to bring it to the notice of the court. This is a matter, right? Item.
end of.
Okay. Where is the single bench order? One three seven three. 31 feet. Okay. That is at page 46.
There's an order at page 26.
That's 26. 26? No, no, 26 is not the order, Mr. Counsel.
Single digit.
No, 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 no. That's not the order. The order is at page 46.
Yes.
Okay, right.
I don't-
Third, Miss Aida, then counsel for the petition. Mr. I bought Thakur, appearing for the respond number.
All the response.
Appearing for all the respondents has submitted letter ECF number 414215, 414215 /110. Dated 18/3/2024, issued by the Chief Engineer Irrigation from Assam, along with the speaking order dated 16/3/2024. The petitioner is granted time to peruse the same and make their submission after 2 weeks. This will be for.
Yes.
Are you filing any affidavit?
If required, not
You file an affidavit. In the meantime, Mr. Bhattakur will file an affidavit with incorporating the said letter and speaking order. How many did you- Have you got?
Required the order, then.
Huh?
The order of the original speaking order.
You you give them a copy. And yes,
Your Lordship, this is second writ petition, Lordship. Your Lordship will kindly come to page 151.
151.
151. This is your Lordship's order disposing of the first writ petition, where the respondent authorities were directed to consider my appeal under the provisions of the Assam Public Procurement Act of 2017. And the appeal was supposed to be disposed of on or before 26th of March. Thereafter,
151 is the appeal.
yes, Your Lordship.
Yes,
I apologize, Your Lordship. Page 146. I apologize, Your Lordship. Page 146 is the Lordship's order. Page 146.
Yes.
Yes, apologize. Page 146 is the order of Your Lordship, where Your Lordship directed the authorities to consider my representation as an appeal.
Yes.
Yes. Thereafter, I was summoned by a letter dated 15/3.
So you were given an opportunity of hearing.
Yes, and on 18/3, Your Lordship will kindly come to page 151. Your Lordship will also be there. Page 151.
Yes.
The relevant portion, Your Lordship, is at page 152.
Yes.
Point number 11, Your Lordship.
Yes.
As it appears that the appellant failed to supply experience of particular items, that is solar light trap type A, solar light trap type B, solar bubble dryer, and solar bubble dryer NP as required by the bid documents, and the respondent was considered non-responsive for the aforesaid 4 items. Then point number 12. The solar power equipments used in agriculture purpose are quite different from the solar power equipment used in other purposes in terms of technology. Okay, this has been disposed of. I ideally do not have any objection to that disposal order. But Your Lordship will kindly come to page 154, which is the summary price evaluation of all the responsive bidders.
154.
154.
Ah.
Your Lordship sees item number 5 and item number 6.
Yes.
So eco-friendly solar light trap and eco-friendly solar light trap type B. Serial number 5 and serial number 6.
Yes.
Yes. In both those items, Your Lordship sees the last bidder, Surya Enterprise.
That's you.
That's not me. That's not me. Surya Enterprises, they came out as L3 for item number 5, and they came as LL5
L3,
for item number 6.
Who is Surya Enterprise?
Surya Enterprises is a bidder who participated in the bid and
But-
who was declared as responsive, but they did not make the financial cut. That is the reason I'm relying on that. Page 157, annexure M. Page 157, annexure M is the past experience which Surya Enterprises had provided. And the past experience here, Your Lordship, is similar to what the petitioner had submitted.
Let us see your past experience.
My past experience, Your Lordship, will find in page 144. Page 144.
Yes.
Yes. I had submitted solar home lighting system, solar LED high mast lighting system, solar photovoltaic pumping system. Then
Not photo type.
Huh?
It is not solar light.
Exactly. That is not solar light.
Solar home lighting system, solar LED,
Yes.
HIMARS lighting system, that is not solar light.
Absolutely. It's not-
Technically, Lordship, he doesn't qualify
Yes.
for
I don't, I ought not to have been considered.
the.
So you see, this person
Yes.
had 157.
Yes. The experience which was required in the bid document,
He has given friendly solar light trap type B, type A,
page 157, here,
154.
it
Yes.
LED based solar lantern.
LED based
Solar
solar lantern.
Yes,
And you have given what?
I had given
So solar home lighting.
solar home light.
It is it.
No, in fact, your lordship,
How
will see,
Solar light trap is solar insect light trap.
What do you mean?
Solar insect light trap. Insect
which one?
for
Which one?
agriculture purposes. The first one, Lordship, it comes to page 144.
144 yes.
Solar light
Light
trap
trap. Unit
is
solar light
solar
trap.
insect light trap
Ha ha ha.
for the agriculture purpose.
Ha ha ha.
And what he has submitted is solar home lighting system. Lordship.
Okay.
That is the
Ah,
solar
that
light
is different.
inside the
Ah.
homes, Lordship. Technically, Lordship, he doesn't qualify for the.
my
How do you say that Surya's experience
yes,
certificate?
that is my submission. That is what I'm relying on. That Surya's enterprise,
Ah.
Surya Enterprises past experience was based on similarity of the items which they provided.
No, how do you say similarity? It is a LED-based solar lantern.
Yes.
It doesn't say for home lighting.
In fact, if your lordship will kindly come to page 158 also,
Yes.
this is pertaining to solar lamps. Now they wanted something.
No, this is with regard to some other NIT or what?
No, this is the same NIT. These are the documents which they have submitted to the authority for evaluation. They made the cut. They made the cut based on similarity of the item.
It is supply order, subject supply order for
Yes.
LED-based solar lantern.
Yes. Yes.
So
But my point here is that the similarity of the items that's put in the NIT. was
where is the similarity? Where is the similarity?
There is no there is
I fail to understand where the similarity. There's no similarity.
exactly, your lordship. There is no similarity, and Surya Enterprises was considered as a viable.
Look, you would have a case.
Yes.
You would have a case.
Yes.
If your item was similar to Surya item, but your items are not similar to Surya item.
Yes.
So Surya item is found responsive. You are not found responsive. So what is wrong?
Similarity, your lordship, would not. My submission would not be subjective. The moment the items are not similar, particular to the quoted items. within the NIT.
These are for experts to determine. Who are we? We do not.
In fact, your lordship, that is what my submission is, that the
What?
experts have decided, the experts that disposed of my appeal,
Ah.
based on the fact that my submission of quoted items were similar, but not particularly the quoted items in the
There was yes, but
But
so
that-
they wanted what was quoted in the NIT. You have not given. They want a solar light trap.
Yes.
Now I know what a light trap is.
Yes.
You see, because I use light trap also in my farm. Because all the insects
Yes.
are attracted by their light and they get caught.
Yes.
Now, home lighting is a different thing.
It's a different, the mechanism is different, but that is not for me, your lordship, to satisfy this court. It is a technical matter. What has happened, my submission to the court,
Your submission is what? That is
my
what
submission is that a different bidder who was eventually not made successful was
Surya.
Surya Enterprises
Ah.
had passed the technical threshold based on similar items which they had
No,
provided.
not similar. A different parameter altogether. Might not have been
Yes.
in terms of the NIT,
Yes.
but nonetheless not similar to your item.
Not similar to my item. It is in fact not even particular to the item which is put in the NIT. That was the ground which was an absolute taken to reject my bid. Your lordship could see that.
I think
The subjective claim is here, in fact, your lordship, the bids were supposed to open on the month of August in 2023. It took 6 months for them to open the bid. And
Whatever.
in 2 days, your lordship, they opened the price bid. There's something not right at the respondents.
Unfortunately, all the panaches in the world
Yeah.
cannot be called by us or, pure.
No, in fact, I'm assailing the decision-making process that the authorities have taken up, where one kind of similarity with the quoted items has been taken as good enough for responsive, and the other has not. That is my only claim. My claim is not to be the bidder here, the selected bidder, the L1 bidder.
No, you see,
If the parameters are
I can understand your case.
Yes.
Or you might have a case, in fact, if your item
Yes.
and that Surya's item were the same, and he was declared responsible and while you were not.
Yes.
On that ground, discrimination is there. But They can play around with the joints.
They can, in fact, there is a government which has been made in the petition, is that the supplier only supply what is demanded or required of. So for a particular supplier to have a particular line of experience in a particular product may not be feasible at all times, but that we're not challenging. In fact, if all the bidders were assessed on the same parameters, the logic I would not have approached the honorable court. In fact, my first disposal was that my appeal should be considered in the light of free section. When this was considered, my appeal was disposed of on the ground that my products were similar and not particular, which I cannot dispute. But there,
Difficult.
what you could kindly see, the parameters which they've adopted, in fact, it gives rise to an apprehension that competitive bidders were ousted at the first go, and thereafter the technical bids were open. That is only let them
Now, if Surya had been selected, maybe something.
technically responsive. They're not even the L1 bidders, so they do not pose any threat.
But the solar light trap is very different
It's
from
very
home
different.
lighting.
It's very different. In fact, your lordship, it is
The very purpose of a light trap
Yeah.
is different from a
it is
home lighting.
in fact, this is the
You,
query that
if
was
you
asked.
put if you use a solar light trap
Yeah.
for your home lighting, I mean, the entire lighting system is going to be full of insects. And all the insects will be trapped.
Which is not like
On the
that.
other hand,
Yeah.
if you are going to use a home lighting
Yes,
system
yes.
as a solar light trap,
Yes.
the only thing is going to do is they're going to give light, get light. That's all.
In fact, the
No,
Technically, he doesn't qualify.
technically, there's nothing.
And he only, touching only on 4 items, he doesn't qualify.
Yeah, any
Based on
citations in
these
your
items, he has
favor?
to consider this one.
In your support of your submission,
this is a very it's a
but
you know,
unique
it's
case.
the LOA in the matter of this tender has not been opened, has not been issued because there is another matter which is pending before the honorable court, and there's a stay operating.
That's a different issue.
I'm not trying to leverage on that matter. Your lordship will not dispose of the matter today. Your lordship will call for the record.
Why?
No, lordship.
In fact, your lordship, what the authorities are saying, the authorities are saying that subjectively, your similarity is closer to my particularity than his. That is what the claim is. In fact, it's a parameter. I have not been given an.
Authorities might say anything unless it's in black and white.
It's not a level playing ground, your lordship, for the petitioner at least. For the petitioner, at least.
World is not fair, Mr. Counsel.
The world is not fair. Your lordship is bound to look fair.
Some people are more fairer than the others,
It is at least bound to act.
more equal than the others.
It is at least
Anyway,
bound to act fairly.
but we have got to go as per the law. We have got no choice.
The similarity is subject. It is basically a subjective assessment by the authority. It is clear, your lordship, because the items which have been provided by Surya Enterprise is also not particular items.
Subjective, we're talking about subjective.
Yes.
Subjectivity.
Yes.
I can understand if your issue was regarding objectivity. If it's subjectivity, then there's so many interpretations.
In fact, objectively, it does not even tally
Then
with the court evidence.
It lessens the requirement of having a specific particular item then.
It does. I do not have that. I'm not disputing that. Even Surya Enterprise is not.
Where is the rejection of your technical bit page?
Yes, your lordship, it is at page 151. The order, in fact, the appellate order. This is what they've stated.
No, but by the technical bid evaluation
Yes.
committee, where is the thing?
Yes, your lordship will come to page 127. 127. This is where the BBC meeting held on 22.
120.
Yes, 127 is where the NHS starts. Page 133 and 134 is where my bids are rejected. Page 133 and 134. Surya Enterprises makes the cut in the same bids. Page 133.
What are you? Yeah,
I'm Trade Supply India. Your Honor.
State Supply India.
Page 133.
Not responsive, not State Supply India.
Yes.
You are responsive. Where are you not responsive?
I'm non-responsive.
Where?
Page 133, the last name here. Trade Supply India.
Okay.
Solar light trap, non-responsive. Surya Enterprises in the same bracket, your lordship, is termed as responsive. Then comes,
So it's basically for the solar light trap.
yes,
That's all.
yes,
Correct.
yes. In fact, there are 4 items that we were not selected for. The other 4 items, third and fourth, is at page 136.
So basically, you are challenging only the solar light trap 5W, 5 watt.
No, I'm challenging the ground on which my failure is.
I know,
If
but
that
then,
ground is allowed, then I
no,
can.
no, but it's,
Yes.
so solar
light
light trap is the main thing.
Type A and type B.
Huh?
Type A and type B. There is
Type A, type.
type A and type B, where I have failed in both, and JK Surya Enterprise have been responsible on both. So that is my ground, Your Honor. Because similarity, they've termed as one similarity to be good enough, and the other similarity to be not good enough. In fact, the suppliers, they only supply catering to the demands of the end customer. In fact, seeking past experience itself can be termed as arbitrary, but that will not enter into it. The fact of the matter is that we will supply whatever is needed, and we are supplying on a mechanism which is very similar, subject to our.
Anything else besides what you're saying? We are going round and round. Yes, let me hear you.
That is what, Lordship, page 144. Serial number 1, Lordship, why he has been rejected.
144, yes.
Yes, Lordship. Solar light prep, Lordship, he has submitted experience of solar home lighting system,
Ah.
solar LED high mass lighting system, solar photocopy pumping system, which cannot be considered technically as supply experience of solar light prep for agricultural purposes. That is the last column. Lordship. So same
What is the difference between this serial number 1 and 2?
solar light prep 5W type A, solar light prep 5W type
It should be type B.
Type A and type B.
type B.
Type B.
This was interfered with by your lord.
Huh?
This order was interfered with because this was purportedly passed in compliance with the appellate provision in the Assam Public Procurement Act. That was brought under before your lordship in the earlier round of litigation. Where your lordship interfered with this and directed the authorities
For
to
the
affect.
technical reasons.
No,
for
no,
rejection,
because you were not
Lordship.
heard.
Technically,
I
we
was
cannot-
not exactly.
Because
Yes,
you were not
yes,
heard.
yes.
That was, that was,
Technicalities, we cannot change it, Lordship.
ah,
We
technically, we were not-
cannot change
it was interfered with only to the extent that he was not heard. That,
Comply with the problem. Yes, yes. This was interfered with. Thereafter, the appellate authority said, and basically said the
Difficult. That's difficult. Sorry.
For agricultural purpose, Lordship, his experience cannot be considered technically sound for our purpose, Lordship.
You're right. Where is the order passed by this court earlier?
your lordship at page 146.
Heard Mr. M. Sharma, Learned Counsel for the petitioner, as well as Ms. R. Bora, Learned Counsel appearing for all the respondents.
1, 2, and 3.
Not all.
No. 4 is the Surya.
For 1, 2, and 3.
Not very.
No one appears. No, the respondent number 4 is the private respondent who was not the successful tenderer in person to the tender notice dated 29/7/20. To submit surrender. The petitioner's grievance is that though his technical grievance is that though the petitioner is though the petitioner no, let us see the NIT. Where is that technical experience required?
Yes.
Page.
Yes, your lordship. Is your lordship. Page 67, your lordship.
67.
67, 4.2.1.
4.2.
Required minimum experience. Item number 5, 6, 13 and 14.
The petitioner's grievance is that though the petitioner's experience experience certificate and in terms of clause 4.2.1 of the tender notice requires the petitioner to have experience for supply of at least 20% of the quantity as specified against a particular item in the schedule of requirements. The petitioner has submitted experience of supply of a different item than what was in the schedule of requirement. Similarly, the respondent number 4 had submitted an experience certificate for supply of a different a different item than what was specified in the schedule of requirement. So however, while the technical bid of the respondent number 4 was found to be responsive, the technical bid of the petitioner was found to be non-responsive. Next. The grievance of the petitioner is that they could not have been different, that the respondents could not have applied different yardsticks. While at the tender technical bid evaluation stage, the petitioner's case in brief is that the that the petitioner submitted his tender paper pursuant to a tender notice dated 29/7 2023 for inverted commas parallel rate contract of agro machinery and minor tools for the year 2023-24 and 2024-25. However, the petitioner's technical bid was disqualified on the ground that the petitioner had given his experience certificate for supply of solar home lighting system, solar LED high mass lighting system, solar photovoltaic sensor, which no, photovoltaic pumping system, which could not be considered technically as supply experience of solar light trap for agricultural purposes as the specific item that was required in terms of the NIT was solar light trap 5W type dash A and type dash B. The rejection of the petitioner's technical bid was informed to the petitioner by letter dated 1/3/2024.
No, you're not. It was initially intimated to us by way of an email on 24th.
By email dated 24/2/2024
Yes.
and thereafter by letter dated 1/3/2024. Full stop. The petitioner thereafter submitted an appeal dated 26/2/2024 to the Director of Horticulture, bracket, respondent number two, respondent number two, in terms of section 38 of the Assam Public Procurement Act, 2017, hereinafter referred to as the 2017. The petitioner in WPC one to another with prisoner, as the petitioner's appeal had not been disposed of by the appellate authority, the petitioner filed WPC 1217/2020 during the pendency of the writ petition, the petitioner's appeal was disposed of by the respondent number two. While letter dated 1/3/24, stating that the items to be supplied by the petitioner were not compatible in terms of the specification provided by the state respondents in the NIT. The further grievance of the petitioner, this is a new grievance, no, the petitioner was further aggrieved with the letter dated 1/3/2024 issued by the respondent number two, disposing of the petitioner's appeal from on the ground that the same was cryptic and no opportunity of hearing had been given to the petitioner prior to rejecting the petitioner's appeal. Next up. WPC 1217 of 2024 was disposed of by order dated 6/3/2024. By directing the respondent authority, by directing the appellate authority to give an opportunity of hearing to the petitioner prior to taking a decision on the petitioner's appeal dated 26/2/2024. Inasmuch as section 38 bracket 2 of the 2017 Act require that a reasonable opportunity of hearing was to be provided by the appellate authority to the appellate, prior to deciding an appeal. Next paragraph. In consequence to the order dated 6/3/2024 passed in WPC number 1217 of 2020. An opportunity of hearing was provided to the petitioner by the first appellate authority, who was the respondent number 2. Thereafter, the respondent number 2 issued the impugned order dated 18/3/2020 by holding that the petitioner failed to supply experience of particular items, that is, number 1, it is here, para 11 and 12, page 152. One thing in that writ petition, no, directed to here, in you also write, uh, uh, consequently, the letter dated 1/3/2020 issued by the respondent number 2, set aside. Then next paragraph. The petitioner's counsel submit that the impugned order dated 18/3/2024 issued by the respondent number 2 should be set aside, in as much as the petitioner and the respondent number 4 had both submitted their experience certificate with regard to supply of the particular items required by the respondent in the NIT by giving by giving a different version, by giving a different type of solar lighting system, while the technical bid of the respondent number 4 was found to be responsive at the technical bid evaluation stage, the petitioner's bid was found to be non-responsive. He submits that the state respondent cannot apply different yardsticks in similar matters, such as the experience certificate issued by the respondent number 4 in the petition. He further submits that the respondent number 4 was not selected as the successful tenderer after comparing the financial bids of the valid bidders. That's all. That's all. That's all. Next paragraph. Ms. Arbora, the learned counsel for the respondents number 1 to 3, submit that the NIT required the tenderers to supply solar light trap 5W type -A and type -B. The petitioner, on the other hand, submitted an experience certificate for supply of solar home lighting system, which was not the requirement of the state respondent. Full stop. He submits, and she submits that solar light trap is used for the purpose of trapping insects in the agricultural fields. While solar home lighting system, as the name suggests, is used for lighting homes. He accordingly submits that there was no infirmity in the state respondent not accepting the experience certificate of the petition, as the same was not in consonance with the requirements of the state respondent. Good stuff. Now, what about the other person? The point number 4, what is the submission?
He has not been considered for the final.
With regard to the okay, you have no submission with regard to that. Okay, I have heard the learned counsel for the part. I will make submission for this. I have heard the learned counsel for the part. As can be seen from the NIT, the state respondents require the tenderer to submit experience certificate for supply of solar light trap 5W type -A and type -B. The light, the word trap used in the said item clearly shows that the same was to be used for trapping insects in the agricultural field. On the other hand, the petitioner had submitted experience certificate for supply of solar home lighting system, which is not a solar light trap used for trapping. It is only used for lighting homes. The above makes it abundantly clear that the petitioner did not have the past experience required for supply of solar light trap FW type A, type. It is not understood as to how a tenderer can demand that the state respondent, should accept an item which is not the requirement of the state respondent in terms of the NIT. When the state respondents want a solar light trap, the tenderers cannot demand that they should be allowed to supply some other item which is not in consonance with the terms and conditions of the tender note. On that ground alone, this court is of the view that there is no infirmity with the decision of the state respondents in holding that the petitioner's technical bit was not responsible. Next part. With regard to The contention of the petitioner's counsel that the respondent number 4 had not given us experience certificate for solar light trap, comma. It is noticed that the certificate given by the respondent number 4. No, this is different. Yes. The certificate given by the respondent number, the certificate dated 21/6/22, given by the respondent number. No. Page 157 is not Surya.
No, the lordship is it will certify that method Surya Enterprises has successfully completed the supply.
Correct.
Yes. We uploaded in the system.
No. I'm saying, but this certificate is issued by Assam. Yes, not by Surya.
Just an acknowledgement that they have made a supply.
It is issued by the Assam Electronic Development Corporation Limited.
Yes.
Stated that the respondent number 4. Note down this read got lost. Assam Electronics Development Corporation Limited states that the respondent number 4 had successfully completed supply of lead-based solar lantern. There is nothing to indicate in the said certificate dated 21/6/22 that the lead-based solar lanterns are similar with the
This is by another department. It's not
Okay.
regarding this particular.
okay, not regarding this NIT, it's not there.
Yes, they have in fact produced the fake documents in the office also.
Yeah.
No, the petition report.
Oh.
And this document is not relating to the undertaking is given by the Assam Electronics Development Corporation. This is not by the agriculture
past.
department and not relating to this center.
No, it cannot be related to this sector. It has to be pursuant
They
to
have
other
been considered
supply.
other subjects
Other supply. Past experience,
regarding other departments.
past experience cannot be particularly to this sector. Past
Whatever, sir. Are similar with the home lighting system that had been included in the petitioner's experience certificate. There is also nothing to indicate whether the lead-based solar lantern is similar to the solar light trap. In any event, comma, the no. So what have you got to say with regard to this?
Okay, this is previous experience certificate.
Was it part of the tender document of the respondent?
Here submission that it was submitted. On oath. It was submitted.
Anyway, okay, right here, you write in the beginning, petitioner's counsel. Petitioner's counsel submits that this certificate dated 21/6/22 issued by the Assam Electronic Development Corporation Limited shows that. Oh, no, what have I said? Just this. Shows that The respondent number 4 had given a experience certificate relating to lead-based solar lantern and not to solar light in his tender document. Then you write Miss S. Bora. Huh? Miss S. Bora, on the other hand, R. Bora, where submits that. Um, submits that what? That this certificate what? That this certificate is not related to the present petition, is not related to the tender document of the present.
Tender articles required in the,
How does it matter?
No.
Is not related to the present NIT. That's all. That's all. Next, come back to where I was. What have I said? It is. Uh, experience certificate. Solar light trap required by the state authority. Be that as it may, the fact remains that the petitioner's experience certificate for supply of items was not as per the requirement of the NIT. And as such, the 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 disqualification of the petitioner's technical bit on that count alone cannot be faulted. The petitioner would have to stand on its own legs and not on the weakness of the respondent in deciding a matter of this nature. It appears that no, though it appears that the though it appears that lead-based solar lantern, as alleged to be the supply items inserted in the experience certificate of the respondent number 4 is not similar to the light trap, the solar light trap required by the state. The D dash dash dash, huh? These are the rules stated above. This court does not find any ground to exercise this restriction. The writ petition is accordingly dismissed. I'll fill that up after some time. I have to think a little bit how to. Unfortunately, no case.
The client felt there was a case, but the parameters, the client always been dated.
How can it be? I know what a solar light trap is,
In fact,
and I know what a home lighting system is.
Your Lordship, the home lighting system is not the only item that is subject to Your Lordship,
But that is your case.
and LED high mask system and LED photovoltaic system also. The three items which I had produced is supplied.
this is for public interest, Lordship, for the
Is
agriculture.
it is the item rate? Is it an item rate contract? Is it item rate contract? Is it each item is considered or is it,
Each
It-
item
it-
is
it-
Each
considered.
item, that's why there is a step on this item.
no, so for, okay, for the other items, if
He's
he's,
responsible in many other items.
Not many other, two others. But that does not disqualify me from challenging my answers of the other. And since
Uh-huh.
public interest involved, they made it.
so out here where you're challenging only the light
Yes,
trap.
yes, yes. That is,
Because there were 4 tables.
Anyway, you see, I've got this, insect trap in my home.
The small
I-
one.
Yes, a small one. It becomes absolutely filled up with insects, especially in the wilderness. It filled up. Right? If you- And if you put a light,
Yes.
it's only going to attract the insects, it's not going to get trapped. No purpose is going to be served.
What the petitioner says that the working mechanism around them is so substantially similar that whatever the end customers they require or demand, it can be produced through the specification. Now the problem happens with regards to the past history. Because there are only a handful of manufacturers who actually deal and manufacture with all of these larger scope of products very logically that I said. So supplying those quoted items is not a problem for any of the suppliers. Supplying of past experience of particular item is where a lot of bidders, even they could have actually supplied to satisfaction of all, they are filtered out.
You see, even the,
But
but
that-
you see, even the color lighting is slightly different.
Uh.
And the frame, they are framed in this insect trap. Where once they go in, then they get caught and they get stuck. And of course, they fall down also sound that. But that doesn't happen in these other lights. It only attracts and then they fly off once you put it back. Anyway,
Sometimes
Great foot. Dignity.
these are actually. The petty.
yes, madam.
The petitioners are husband and wife, and they are running their grocery business in the space allotted to them by the BCR Municipal Court, the district of Lakhimpur. And after being
Since
given,
when?
the petitioner number 1 since past 35 years, and petitioner number 2 since 2004, past 10 years.
2004
Past 10 years. Their life,
will be 20 years.
yes, 20 years, sorry. The petitioners have been issued licenses, and that has been
Let us see the licenses.
periodically lordship renewed.
Let
The
us see the licenses.
The latest renewal license that pays 40.
No, I want to see the original license. I don't want to see the renewal.
Original lordship, the old licenses are not available. In fact, the latest license, which are periodic year by year, it is renewed. So the original, the other licenses are not relevant at this stage. That is why we have
Because you see, the original license are relevant because then we know from when you started having a license.
but these licenses itself show that it is still on the operation.
No, that is all right.
Yes.
You said that one person and the husband was for 30 years, the wife is for 20 years. Now, whether that is correct or one is for only 1 year and one is only for 2 years, that will prove that. That will
The
prove that
money
issue.
receipts are also there.
Huh?
All money receipts, we have enforced.
Let us
the
see.
old money.
Let us see.
Yes.
Let us see. You see, the trade license is there, page 14.
Phase 14 and 15 are the trade license. And
License issued in the name of Sudev.
the license are valid
Sudev.
till 27th of April to 2024. And the
Date of issue of license 28 for
one
23.
lordship, one license of the year 2017, we have enclosed 2020 and 2017. Lordship will peruse page 17. The license issued in the year 2019-20 in respect of the petitioner number 2, 31/3 valid till 31/3/2020. Then license issued again in favor of the petitioner number 2, page 18, in the year 2016-17. 2016-17. 31/3 up to 31/3/2017. Then the month followed by the money receipts. The oldest which is put these are 2024. One pertains to the year 2007 at page 23.
Madam, one thing. You see your page 14 and 15.
Yes.
Speaks of the trade license being issued under section 2291.
Yes.
Of the Assam Municipal Act 1966. Let us see this
Yes.
assignment.
And if your lordship is.
And wait just a minute.
Yes.
And the next one. And page 16 and 17
2291. Yes.
speaks of the license being issued under the Assam Act of 1926. What is the difference?
Both are not issued under the Assam Municipal Act.
Say the Assam Act, it does not say Assam 19. The Assam Municipal Act is of 1956.
56.
The Assam Act is of 1923.
Previously it was the Assam Act, and now it is the Municipal Act of 1956.
I doubt.
229(1) regarding license.
So what has happened?
And now they have been issued an eviction notice stating that one of the rooms has to be vacated because it cannot be issued to members of the same family. But the Act does not provide that members of the same family can be allotted, whether can be allotted license or not. Because 229(2) itself provided under which the license can be cancelled. The Act itself contains. And it does not provide that whether members of the same family can be or
Where
cannot
is your Municipal Act?
Municipal Act, at page 113 of that book.
Yes.
113. 229 is certain offensive and dangerous traits not to be established within the limits to be fixed by the board without license. In other words, the under which conditions in case of which businesses licenses are to be issued. This is what 229(1) says. And since we fulfill
Certain offensive and dangerous traits not to be established.
within such local limits as may be fixed by the board at a meeting, no place shall be issued without license from the board, which shall be renewable
Certain offensive
annually for any of the following purpose. Only for the purposes indicated in 229(1), licenses shall be issued. That is what is the purpose of 229(1), it appears. And 229(2) says subsection 2, under which the license can be written. Next page, Lordship.
Where is the power to allot license?
And there is no other specific provision except this,
Where? Which section?
except this 229. That is why even the license indicates only 229.
Look for the other side.
Not if the notice will have to go because there is no standing guard. But what I would like to say is that since the license is still valid till 27/4/2024, we will be protected at a still date and that notices for legend action because there appears to be no provision in the act under which it says that.
No, you're protected till 28/4 anyway. Acha, you might be evicted because of.
Yes, yes.
Third means he were behind the also for the protection to submit. That's the petitioner and his wife.
Yes. One is the husband, is the wife.
Are agreed by the decision of the respondent number 3 to cancel the allotment of 2 rooms made in favor of the petitioner, comma, on the ground that
Twenty-eight is the interim.
on the ground that they belong to the same family. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondent by registered post dated within 3 days. Or within the course of the day,
Within the course of the day.
within the
But
course of the
file,
day.
lots of record will not move there.
Huh?
Record will have to be available probably. Record will have to go for
Okay,
us.
fine.
We'll fix them.
Huh?
Record will be.
Uh-huh. You take steps within the course of the day. In addition to the above, the petitioner shall take steps for service of notice by dusty service upon the respondent number 2 and file affidavit of service. Within 4 weeks. This is a matter on pivot date. Huh? No. First, no, this is 28, it's 28. See, 28 is the last week. It's 28,
27th of April.
27, 27. No, make it 27. 26. 26, huh? In the interim, see, letter number PMB dash 2023 dash 24 2024 dash 444 dash 4 dated 13/3/2023 issued by the respondent number 6 shall be kept in abeyance till the next determination.
There are 2 letters issued in respect of both the petitioners. There are 2 letters
Okay, 2
issued
letters.
separate. Yes. Issued
Is
separate.
it the number same?
Number is same.
Okay, 2 letters, letters, huh? That is a page 28. Page
And this 26.
2 letters, it is 2 letters, this number says the 2 letter number says page 28.
19 is also similar logic. Members of the same have
Huh?
only lordship in rest. Members of the same family, husband, wife, and son.
Okay, out here, I heard Mr. Spencer and possible for the petition to submit that by letters number, by 3 letters, by 3 letters,
3 letters.
3 letters bearing number BMB slash 2023 dash 2024 slash 445 dash 4 dated 13/3/2024 issued by the respondent number. The petitioners who are
Lordship, there is
brothers or what? Huh?
Lordship, there is one factual difference here. So far as the petitioner number 3 is concerned, the license is yet to be in her name because she is occupying the space that was allotted in favor of her father-in-law. That is the father of the petitioner number 1. We have made it clear in the petition. But she has applied for permission for transferring her license.
Who are related?
That is under
Who
process.
are related?
And they have issued the
After we evicted. Just a minute. Who have to be evicted. The issue notice, returnable in 4 weeks. That is same thing, additional paycheck. Then you write. What is the relationship between 1 and 2?
One is the father and two is the son, and three is the
Petitioner number 1 is the father of petitioner number 2. And petitioner number 3 is the
wife of the petitioner number one.
wife of the petitioner number 1.
Here the license is valid till 17/5/2024.
Isn't it? Same
Right.
interim or back. Item?
As far as this of this report from the last occasion, we have already sent a letter to the CBI lordship for allowing us to inspect or supply the records. As all the fields are also with there, it's in there.
So you have sent a letter. What have you done?
Only 1 week time may be allowed.
Miss
And
MM Protocol Learn Concept for the response submit. That letter has been written to the CBI court to allow the respondents to inspect the record. He submits that. Last time also you had said the same thing, madam, 10 days ago.
letter after order.
He submits that. Affidavit will be filed within 10 days. Accordingly, this is matter when
When?
10. Make it 10.
Ma'am, sir, pertain to withholding of my fisherman certificate. My fisherman certificate is page 16.
Yes.
Page 16 is my fisherman experience certificate. It was issued by the District Fishery Development Officer, Bongaigaon. It was issued on 13/6/2018 by the Union Order dated 27/6/2018, which is at page 23. Page 23.
Yes.
Based on a public complaint received on 26/6/2018 from the Secretary, Kochudola Fishery Cooperative Society Limited, Kochudola, the certificate issued right
Withheld.
number so and so is hereby withheld for all purpose till further order with immediate effect. It has been withheld.
Then after that, you went to the rich court. You came to this court.
No, thereafter some developments appear. Thereafter, the district fishery officer asks his subordinate officer to enter into the matter. And thereafter, the subdivisional fishery development officer on 11/7/2018 at page 29 submitted a report to the district fishery development officer. It's a typed copy with reference to the subject cited above and in continuation of the letter number so and so submitted by
10 to 20 years experience.
they found I have experience of 20 to 20 years. So even after receipt of this report,
What is this High Court order?
High Court order is that not this. With this fisherman certificate, I had participated in a tender process. And in the tender process, I was declared as valid. My bid was declared valid. And hereafter, one of the bidders who failed in the bidding process, he lost an complaint.
That your fisherman
My
certificate.
fisherman certificate is
So what happened to that bit? That's that case gone.
no, that has gone already. That tender has been
Yes. What has
put
happened?
in my process. I have
some instructions of the characteristics. So that Fisherman experience certificate was issued by the officer. Later some public complaint was there. The public complaint they have stated although the petitioner is a civil class man,
Is that?
including the civil class man,
Okay, yeah.
but he doesn't have the experience of fishing.
Who has said?
Some lordship.
So no, what is your latest?
Then lordship that district fishery development officer got a clarification before regarding the financial status in the year 2018 itself from the SBO, but no reply has been received
From whom? From SDO.
from the SBO. So it does lordship.
We'll tell the SDO to come up here if he doesn't want to come. Where is the letter? To the SDO?
In my instruction, I have like
Yeah, 2018.
Yes,
The officers
now
must have changed.
here running the fishery also.
That is not the issue. Are you? Do you think some officers will still, or they will still know about the letter issued in 2018?
Otherwise,
What have you taken steps?
otherwise, Lordship, district fishery development officer is a competent authority to issue the certificate. If your Lordship gives direction to this officer, both the parties should be heard together and pass a necessary order against this complaint. That will
Which party should be?
Lordship, district fishery development officer. Respondent number is the
May complete one. In view of the report submitted by the subdivisional fishery development officer,
Respond
at
number
page
2.
29, there is
Yes.
no necessity for another hearing. Because it is in this
Correct.
communication, it has been clearly stated.
Correct.
I belong to scheduled caste community and I have fishing experience of 10 to 20 years. So there is no necessity at this point.
Correct. Correct. Third, Mr. T. Chowdhury, Senate Council for the Petition. And Mr. S.R. Barwa, Senate Council for the Fishery Department. The petitioner is aggrieved by the withholding of his fisherman certificate dated 13/6/2018 due to one alleged complaint made by whom?
Secretary, Oshudola,
Is he a respondent here?
no,
Made by one?
at page 23, it is written. Secretary, Kochudula, Fishery Cooperative Society. Limited.
Made by the Secretary Kachudula Fishery Cooperative Society Limited. Kachudula. The petitioner counsel submits that even though the subdivisional fishery development officer had submitted his inquiry report regarding the status of the petition, wherein it was stated that the petitioner belongs to the ST community, subcaste Namusutra, and had fishing experience of about 10 to 20 years. No final decision has been taken by the district fishery development officer till today. They accordingly submit that The direction should be issued to the district fishery development office to take the decision as to whether the petitioner fisherman certificate should continue to be withheld or it should be, or the withholding order should be recalled. Mr. S.R. Barwa, the learned counsel for the, for whom? For the,
All the
submit that with regard to the withholding of the petitioner fisherman certificate, comma, the district fishery officer, Bongaigaon, has issued a confidential letter dated 6/7/2018 to the subdivisional officer, bracket civil, North Salmara, Abhayapuri, requesting him to furnish a livelihood status of the petitioner after verification. He submits that no reply has been forthcoming from the SDO bracket civil to the district fishery development officer till date. Next, I have heard the learned counsel for the past. The issue pertains to the order dated. No, it pertains to the withholding of the petitioner fisherman certificate dated 13/6/2018. Five order dated 27/6/2018 passed by the district fishery development officer, comma, which states as follows. That is the last order it is for the. Next. The report of the inquiry report of the subdivisional fishery development officer, North Salmara Development Block, which has been submitted to the district fishery development officer, Bongaigaon, is to the following effect. Page 29. From here to here, right? Huh? The above being said, comma, the district development, the district fishery development officer, bracket respondent number 2, has written a letter to the SDO, has written a letter to the SDOC. Bongaigaon. Not Bongaigaon, North Salmara, Abhayapur. Requesting for a livelihood status of the person. Nearly 6 years have gone by and no report has been forthcoming from the SDO. The above being said, the above being said, this court fails to understand as to why a decision cannot be taken by the respondent number 2 in view of the findings in the inquiry report made by the respondent number 3. The grievance of the petitioner cannot be kept hanging for 6 years due to the inaction of the official of the concerned official. According, keeping in view the facts and circumstances of the case, respondent. The respondent number 2 is directed to take a decision as to whether the petitioner fisherman certificate is should continue to be withheld or the withholding order should be cancelled, by taking into consideration the inquiry report dated 11/7/2018 issued by the respondent number 3. The the entire exercise should be concluded by the respondent number 2 within a period of 1 month. For 1 month from the date of receipt of the copy report.
Experience.
Fisherman experience certificate. The rate petition is accordingly disposed. That's all.
The respondent 4 has filed an affidavit yesterday. I need 4 weeks. And we have to settle for it.
Mr. T. Over, no. Mr. R. Goswami, learned copy for the petition. Submit that he has received affidavit in opposition filed by the respondent number 4 yesterday. He accordingly pays for 4 weeks time to file affidavit. And Mr. M. Smith appears for the respondent number 2. That is copy of the affidavit now. And submit that he has not been served a copy of the affidavit number. The same being served upon Mr. M. The prayer of Mr. R. Gogoi is allowed. R. Goswami is allowed. This is a matter of 4 weeks.
All right. Five.
Lordship, here the petitioners are protected, Lordship, but I have not received any instruction.
Okay, right. No one appears for the petition on call. Ms. D. Sharma, then it's possible for the respondent submit that she has not received any instruction. Aaron. Next to that. In terms of the earlier order dated 4/3/2024, the respondents are allowed to continue with the selection process. However, no final order such as letter of acceptance from a work order, etc. of the successful tenderer shall be made, without leave of the.
By my instruction, still here they have no appended technically.
It's okay, so it's the order since.
Yes.
It's technical bit not open.
I'm trying to even tried over phone also, but
Wait, you say that Mr.
Eboro.
A. Bora,
Eboro.
A. Boro appears for the petition and submits them. As per his information, the technical bits of the tenderers have not been opened still. Then Ms. B. Sharma says the principal, but then you write next para. In view of the submission of the petitioner's counsel. No, then you don't take better. So no final order with. The earlier interim order slight mistake for the corrected. Leave the matter after the appeal. After the amendment. Please, the case. Secondly, order.
Okay, item 7 and 8.
Huh?
In item 7 and 8, I have been instructed to before. This is relating to the payment of upcoming. There are 3 things. One has been cleared in respect of 2 3 weeks of.
Mr. Counsel.
Yeah.
Let me read all your orders.
Look.
11/4/26, Miss M. Devi, Learned Counsel appearing for respondent number 2. She prays for and is granted 4 weeks time to file counter.
Affidavit has been filed.
Then
Uh,
29/11, Sri Dinar, 3 weeks time to appear this fact. Next case, 26/2/24, next order. Dinar, submit that he will obtain instructions as the amount available to the petitioner itself, and 2 years have passed in the order. The next order, 6 March, a general prayer has been made on behalf of Mr. Dinar on the ground that he has not obtained instructions till date. Next, again, 56, Mr. Dinar prays for subside as the ASCO concerned has joined this. How many times are you going to ask? Then
But we have filed the affidavit that they have already sought for, they have written to the authority for find this, fund is not. And in the meantime, one bill has been clear. In respect of two mala, they have paid for.
Huh?
They have paid for to release the fund is not available. Now that now because of the election for Kelly, they have instructed me to go for 4 weeks.
it is they're only instructing you to, the problem is they're only instructing is time. They're never instructing you that they will pay.
But in the affidavit, we have shown that they have first of the fund. In absence of the fund, he is not in the position.
The thing that this pertains to which year?
But it is old. Okay. And it was of election roll of 2013-15. One, and the other is 12.
Amount was also so small,
Yes, sir, the amount is also
only 1,40,000.
1,47.
By the time we dispose the matter, maybe your grandfather and his grandchildren would basically take something there. The weight is going, but maybe too much.
That I agree. That I agree.
Affidavit was filed on 15 November 2022 by.
Yes, sir.
They have admitted the amount.
Admitted the amount fund was for
Amount.
There was an earlier case of what? Was there earlier
No.
directive?
Yes, yes, already this is contemplated in the Repetition Lobsters Act.
Huh?
In the Repetition Lobsters Act. Direction is there.
It's correct. Mr. Srinath, thanks for some more time. As funds are being for payment to the petition. This is a matter. May 1st.
I have.
But
if it's possible, madam.
When can you, yes, what to do?
on currently speaking on 19th of April, election is there. Voting is there. Can you take after that?
That's what I'm saying. First, no. Wait,
First.
third.
First.
Obliged.
If you had the Learned Counsel, Mr. D. Chaudhary was directed to obtain instruction.
Huh?
He was directed to obtain instruction.
Have you seen this?
My friend has informed me.
Yes.
Okay. But your lordship, it goes against me. But what about the emails and the vouchers which they have received? Officer changed their stand. That is my contention, my lord. Because your lordship, emails have been sent. Page 22 to 26 are the emails. And your lordship, the vouchers which I have annexed from page 27 onwards, my lord. They have received the materials and supplied
They
to
have
the
received the material.
lordship.
They have
They have
received
received.
it.
Your lordship, may kindly have a look.
But
All the stills of mission director.
Lordship, the emails were given by the concerned personnel of their own email ID. And about the memos and everything that they have annexed. Lordship, they have verified the stock records and everything. Nowhere it is shown to be received by them. Nor if so received, Lordship, even if there was mistake in recording it. But and for each and every district that has been sent out, the outgoing is also not there in the
But the problem where these
Okay.
receipts come, let them deny, these are not their sin. And
Lordship,
signatures,
the receipts were given by the petitioner, Lordship.
let them file one affidavit, my lord.
But in any event, madam, this is going to be a disputed question for that. Can this court decide?
That cannot. Your lordship, let them file an affidavit, giving their stand, until stand.
Why don't you make a short affidavit,
Yes, my lord.
then we can direct them to go. Yes. So that, right. Mr. B. Chowdhury. Now, after for the response number 2, 3, and 4, submit. That as per the letter issued by the executive director, SSC. The letter dated 27/3/24, huh? Issued by the executive director, SSC. The petitioner is not entitled to any use in as much as no NIT was invited by.
That's my case, I have
No, no, no.
submission.
No?
No NIP.
So no work order was issued in your favor.
No, verbal instruction of the officers concerned who were holding.
Madam, that verbal is a. That is not how office doesn't function that way.
Then lordship,
You go and file a case against that officer.
I have made them as a party respondent personally. And service report is awaited, my lord. Let them say, your lordship.
This is not a, when the respondents have taken this stand. This is not a private dispute arena. You have to go to the civil court.
I have, this is the official materials, Gunutsav, the education department in the Sarva Shiksha Vision Mission. Lordship, they conduct Gunutsav, my lord, every year. To see the standard of institution. And
Anyway, you file a small affidavit, where will you close it? Something that no NIT was invited. No, by the respondent, nor any work order issued in favor of the petitioner.
that is my case.
Huh?
That is my case.
That is your case.
Yes. But in spite of it, they have received the materials and supplied to the instruction. I've carried out the. whatever.
You see, that does not give you any handle.
Even the
That
petition by
basically shows that you are hand in glove with the official.
lordship, no, I'm not. Because I
You
have
are hand in
read
glove
with
with
the
the official.
officers concerned.
Because you see, as per the procurement policy of a state government, they are supposed to follow rules. As per the Procurement Act of the Assam,
I know,
you've got to follow rules.
yes.
Now, if you say that we have done this verbal thing, everything is verbal, that means that you have violated the tender laws
That-
and the
yeah,
act
that
of,
is,
then
my lord.
you're liable.
But because lordship will kindly note one thing, for issuance of the tender notice, minimum period is required. The state government took a cabinet decision to conduct Gunutsav in a short period of time. And for that reason, I was instructed because the state government didn't have the required amount of time, which is required for issuing NIT, my lord. And for that reason, at the lordship, at the RD,
Any work order issued to you?
no, that is
That-
my
that's
case.
the
I have made submission. And your,
Madam, that is the problem. When you do this kind of work,
my lord,
when you do work, this kind of, under the table work.
under they will
No,
not-
I mean, it's not overboard.
Yes.
It's not a transparent
Right.
process. When you are doing something of this work, then it's a risk you take. Now, unlucky for you, now they've changed their stance. Maybe there was a change of officers, maybe. But then that you are the one who's going to suffer.
And your lordship will kindly go
We
42
cannot
lakhs, my lord.
Huh?
42 lakhs. Not even-
Whatever, what to do, that is the risk you take. That's why you shouldn't do this kind of business. Because you'll have no legs to stand on.
Let us find out.
Government will say that we are not accountable.
Yes.
No, madam, when you say this, there is no case then.
No, your lordship, even the disputed question of fact, they will lie, your lordship. Lordship. Lordship is
There is
aware
no
of that.
case at the end of the day.
Let them find their affidavit, let them fix it, sir.
No, it's here. When you yourself had, I thought it was their case. Now you are
My
saying,
case, no NIP, lordship, because of the urgency, we have supplied the materials to the government. And they have duly accepted it. Now they cannot. After they have duly accepted the materials, lordship will kindly see, section 65 of the contract act. They are liable to pay compensation, madam. Because
you see, all contracts have to be made under the name of the president or in his name.
why not?
Okay.
Why not?
Now, where is that? Where is that? Where is the concluded contract made between you and the government?
That is not there. Lordship, there's an instruction, my
At the
lord.
end of the matter.
Lordship may, no, my lord, lordship may kindly give me some time. Lordship may kindly see the communication issued by the executive director, based what these things onward. Lordship is satisfied,
No, you can satisfy me now. Then why should we wait for another day?
let them find their affidavit, let them give it on oath. The no work order is in the position that I have not delivered the materials. They have not accepted the material.
Okay,
Lordship, I'll satisfy, my lord, short date be given.
you tell me now. You satisfy me now. When there is no NIP, when there is no work order, that means your agreement is not with the government, it's with a particular officer in his capacity as an officer, maybe. But that does not bind the government. You go and file a case against him as
It's
per
a-
law.
Yeah, he was the official of the government, my lord. The
Correct.
government is entitled, and the Gunutsav is of the lordship government in the Samagga Siksa
Okay,
examination, they conduct it. I satisfy, my
I
lord.
understand your predicament, but the problem is when you do this kind of work,
Have to undertake the.
then yeah, then there's a risk involved. And
Lordship,
now,
I'm satisfied.
unfortunately, there's nothing to satisfy, madam. Legally,
Coming
there's
week,
nothing to satisfy.
lordship today, lordship, one of the family members is hospitalized. I'll satisfy the coming week or after the view holidays. Let them enjoy view, my lord. I'm not taking any.
You make a small affidavit.
Yes, yes.
Okay, so
By next week.
we'll dispose it. Whatever it is.
Ah,
And no work order was issued to the petitioner. Good stuff. Miss uh, B. Bhuyan, the learned senior counsel for the petition, submits that it is the case of the petition that no NIT was invited for procurement of the materials that had been supplied by the petition, and neither was any work order issued to the petition for supply of this.
I'll do some research if I get some order
This is the matter
after view holiday.
after the view.
Okay.
Very difficult.
Lordship, I have to-
Maybe a little bit. In your country, Mr. T that out of civil matter.
Who?
Mr. T that. Another thing, last thing you notice, my lord, we have taken statement. Service of our test. That's not okay.
Yes.
So I have received my report. Last order, my printer directed to my deputy. I have received my report. I can. Yes, ma'am. It's some kind of and the matter of by admission form. Yes.
So when there is a on the way, 11. It is particular. Okay, right. Who is here for whom?
I have 10 minutes. 10.
Mr.
Ether.
A.
Ether.
Ahmed, then talk about the petition. Praise for adjournment on the ground that its senior Mr. Tita is out of station. Good, sir. Mr. S. Bora appears for the BTP and submits that he has got the report. Mr. J. Ahmed appears for the respondent number 10. No one appears for the respondent number 11. the notice had been issued to the respondent number 11 to usual process on 22/3/24. So we have got to wait. Not even 2 weeks have passed. Not even what? 20, not even 1 week has passed. Await service report. Uh, uh, await service report. You have to file affidavit.
My friend, my friend, yeah, I can.
I will file, I don't think you will file.
His extent is.
Okay, the respondents
Liberty
are
to file.
given, the respondent shall file their affidavit within 2 weeks. Within 2 weeks or 3 weeks.
I cannot file because
You cannot or you don't, that is not my problem. You don't want to file, don't file. The respondent shall file their affidavit, if any, within 2 weeks. List the matter on. When do you want? After vacation, huh? Nice.
19, follow?
19.
April or 22nd. 22nd, madam. 22nd.
Interim order to continue till final disposal of the case. No. Okay, till the next date. Till the next date.
Same, madam.
Same. Out here also 11 is not there.
Yes. Consider the particular reporting order report accepting the award passed by the landed River Coast Guwahati in reference number lordship 1 of 06.
Just a minute, award dated
Award dated lordship 18/9/2017
18/9/17.
in reference number
Reference case number
01 of 06.
01 of 06.
What happened in this case lordship and for the management, three workmen are involved in the case.
Respondent numbers?
Responded 2, 4, 2, 3, and 4. I have got 3 minutes. One question. 2, 3, and 4.
Respondent 3, 2, 3, and
2,
Four.
3, and 4.
they are workmen.
All three were workmen. What happened with the lordship? Respondent number 2 expired.
When?
Uh,
During the proceedings of the reference case or what?
the proceeding before this honorable court.
Of this case.
After the death of the respondent number 2, his legal aid approached the management and they accepted the order of the management.
Okay,
The order was compulsory retirement order.
okay.
So they have accepted the compulsory retirement order and they've taken all the benefits from the management.
So now out here we have got
And
respondent number
another-
3 and 4 only.
Another, number 4, respondent number 4, he
Just a minute. R2 died
died and his
and
legal aid
during the proceedings
in this process.
and management has accepted the award.
The legal aid of the respondent number
Acha, and the legal there have accepted the award.
accepted the
And the
of the respondent
have
accepted the order of the management.
accepted the order of the management.
Yes, because award is against management.
Acha, order. What is the order dated?
No, I'll take it out. Okay. I'll give the sort of order. And in respect of respondent number 4 also,
Yes. Same.
similar thing happened, but in this case, he is alive. First.
Who is it?
Respondent
Acha, respondent number 4 has accepted.
he himself has accepted. Now, on the respondent number 3 is before the honorable court.
Okay. Well, now what is, let us see the impugned order.
Lordship, page 233 of the judicial document.
233.
233 is the reference.
Huh?
233 is the reference placed before the planet labor.
233.
Here is the
APU.
reference.
Oh, this is
It's
the
the
reference.
reference placed before the planet labor code.
Then this is not the impugned order.
No, no, this is the reference law.
When I
I'm sorry. Next page is the cover. Page 230 is the reference page before the planet labor code.
is before whom?
The labor code by the appropriate process.
Dated.
Dated lordship 9th of May 2014.
Yes.
May read the
Yes,
schedule.
yes.
May schedule lordship. The schedule is the issues referred to the labor code. Whether the management is justified in the schedule lordship, whether the management is justified in giving compulsory retirement to their workmen, Muhammad Abdul Jalil, Pitadhar Nath, and David Mishra in place of reinstating them in their services along with back wages as demanded by them. And if not, what relief is their entitled? And lordship, page 34 is the app.
No, Mr. Counsel. What happened? What is the issue? Where is the order? What- Due to which they have to go to for reference. Where is the order?
Order passed by the management.
That should be, that is the start.
On lordship, lordship. Lordship will find the order of the manager at page 172. 172.
Page 172.
172.
Yes. Show me.
172.
Yes.
Made it order. Whereas the Vidyathanath, the respondent of the lordship, was charged by number such and such, stated such and such for different cases. That is one for insubordination, violation of office discipline, threatening to the officer, superior officers, variety of behavior, obstructing the waiting worker from working, threatening the employees with dire consequences, misbehaving, Priya Shakti Devi, leaving office without permission from the competent authority, negligence of duty, confinement of employees in the office room, and unbecoming of an employee of the committee.
Order dated
Order dated lordship will find at 0403/2009.
2009.
Yes.
Yes. Carry on reading.
Along with six Soko's notice, along with the six Soko's notice, charge sheet, a statement of allegation and list of documents by which the list of witnesses by whom article of charges proposed to be sustained were also forwarded to the Petitioner. On receipt of Soko's notice, the Petitioner submitted his replies denying the charges level against him. By this reply dated 24/1/06. The management not being satisfied with the replies furnished by the Petitioner decided to hold a domestic inquiry by an independent person, and accordingly Timothy Bobita Das Advocate Guwahati was appointed inquiry officer, which was duly communicated to the Petitioner. The Petitioner duly participated in the inquiry and cross-examined the witness of the management, and after closure of the evidence of the management, the Petitioner also adduced his evidence to the inquiry. The inquiry officer holds the inquiry, giving all reasonable opportunities to Petitioner to defend his case. The inquiry officer submitted his report and finding on 13/7/2008. The inquiry officer held that the management have been able to prove the charge number 1, 2, and 4 partly. The report and finding of the inquiry officer was forwarded to the delinquent officer, Sri Vidyathanath, to which he replied on 15/9/2008. The relevant record, including the charge sheet, reply to the charge sheet, report, and the finding of the inquiry officer, reply to the report and finding of the inquiry officer by the delinquent official, and the document proved during the inquiry were placed before the executive committee on 3309. The executive committee have carefully gone through all the relevant records and after carefully considering The executive committee was of the opinion that the charge level and proof against the Vijayanath were serious in nature and no lenient view can be taken against the Vijayanath as he, along with others, confined the officials of the committee in a room for more than 8 hours and obstruct the willing worker from working and shown riotous behavior towards the higher officials and pretended the superior officers. The executive committee decided that for the interest of the committee, the services of the Vijayanath could not be retained in the committee any further and he be compulsorily retired from the services of the committee as provided under chapter 5 penalties and chapter 4 of the chapter of service conduct rules of the committee and accordingly Sri Vijayanath he and is hereby compulsorily retired from the service of the committee with effect from 4309. Further, the executive committee also came to the initial decision that Sri Vijayanath shall get the amount as per rule of the committee. Presently, the amount of gratuity amounting rupees such and such is enclosed here by account page check number such and such for acceptance.
Where is the show cause notice 11/11/05?
Plot. Plot 11/11/05. Have been, I think, 5/11.
Is it? I don't know. At
Look,
page
page-
172, it
Look,
says show cause.
Page 91, look, category. Page 91.
Five 11. Yes, 5/11. Yes, in the impugned order, it is wrongly written. Yes, please read.
Plots. Show cause. You are hereby required to show cause as to why any of them, any of the penalties prescribed under chapter 5 of the service conduct rule of Assam Rashtra Bhaja Prasar Committee should not be inflicted on you on the following charges based on the statement of allegation attached herewith. That while you were working as LDA in the Assam Rashtra Bhaja Prasar Committee, in short, the committee, you were placed under suspension by office order number such and such dated 26/2005 and the student peon of the committee was asked to hand over the state suspension order to you to the peon book. And when she went to deliver the state order to you, he refused to receive the state suspension order. He was charged with insubordination, violation of office discipline, and unbecoming of an employee of the committee. Number two, that while you were placed under suspension, you refused to receive the aforesaid suspension order from Sri Jagdish Gogoi, a peon of the committee, and a state suspension order was sent through registered post with AD by registered letter number such and such dated 24/6/2005. But the postal authority returned the state registered letter to the sender, that is the committee, with an endorsement refused. He was charged with insubordination, violation of the office discipline, and unbecoming of an employee of the committee. That while you were working as LDA, you on 7/10/2002, at about 12 noon, when the executive committee meeting of the committee was going on in the office chamber of the Mantri, you along with others entered into the office chamber of the Mantri and demanded to revoke the suspension order of the Vimal Kumar Nath, Sri Shailen Sharma, and Sri Simbechar Bora, failing which he along with others pretended the officers, members of the executive committee to confine in the room and
Mantri will be what, minister?
Mantri is the Lord Secretary.
Not a minister.
The secretary of the office there is known as. Other Pretender office, you are a member of the school committee to confine in the room of the subsequently he along with others closed the gate and tried to attack the official of the committee. You are therefore charged with riotous behavior pertaining to the superior officer, insubordination, threatening the executive and officials of the committee, and unbecoming of an employee of the committee. 5. That while you were working as LDA in the committee, you on C11-2003 at about 12:30 p.m., you along with some other employees of the committee misbehaved Srimati Priyasaki Devi, Mukha Prakashanik Adhikari of the committee in the office of the Commissioner from my Education Department at Assam Secretariat, Dispute. You were therefore charged with misbehaving Srimati Priyasaki Devi, an officer of the committee, violation of office discipline, insubordination, and unbecoming of an employee of the committee. 6. That while you were working as LD in the committee, you left the office on C11-2003 at about 11:30 a.m. without any without any authority or permission from the competent authority, and you, along with others, misbehaved Srimati Priyasaki Devi, Mukha Prakashanik Adhikari of the committee in the office of the Commissioner Education Department at Assam Secretariat, Dispute at about 12:30 p.m. to 1 p.m. He was therefore charged with insubordination, violation of office discipline, and leaving the office without permission from the competent authority and negligence of duty. That while you were working as LDA in the committee, you on 15/4/2005 at about 10 a.m. when the committee tried to shift the stationery file furniture of the office from Hyderabad to Rupnagar, along with others, obstructed the workers and threatened them with dire consequences. You also threatened the Mantri with unparliamentary work and closed the main gate of the office, as a result of which the Mantri, Pradhan Khusip, advisor, and other office bearer of the committee were confined to the office premises from 10 a.m. to 8 p.m. on 15/4/2005. He was charged with confinement of the employees of the committee, obstructing the willing workers from the working, threatening the employees with their consequences, and unbecoming of an employee of the committee. 8. That while you were placed under suspension on 27/4/2005, and though you were not asked to attend office during the period of your suspension, but you regularly came to the office and attended the officers / employees of the committee, committee with their consequences of the life, and you also pretended to murder them. You were therefore charged with riotous behavior and unbecoming of an employee of the committee. You should submit your written statement in defense within a period of 15 days from the date of receipt of this communication, provided you do not intend to inspect the documents you have relevance to the issue under inquiry. In case you intend to inspect those documents, you should write to the undersigned for the same within a period of 7 days from the date of receipt of this communication, and submit your estimation thereafter within 10 days from the date of completion of the inquiry. The list of documents, then the statement of allegations to their lordship. And lordship page 99, he replied, lordship.
No, he replied at 102.
He sought for some documents, lordship.
102.
102, he replied, lordship, denying the charges.
Okay, then let us go to the award.
To the award. Lordship, after that report, the inquiry officer conducted the inquiry, and report and finding was submitted to the office.
Where is the report? Inquiry report?
I have also annexed the evidence also, lordship. The record is before this honorable.
Where is the inquiry report?
Lordship. Lordship will find the inquiry report at page 146, lordship. 146.
How many charges were framed against him?
Lordship, 10 charges, lordship. Out of this, lordship, inquiry officer found charge number 1, 2, and 4 partly as proof, lordship. The relevant part of the inquiry report, lordship, where lordship is come to finding at page 151. Considering the evidence, I hold that management has been able to prove the charge number 1, 2, and 4 partly, and the manager failed to prove the other charges labeled in the that finding us page 151. May I read the award law?
Yes.
It's page 234.
My God, very long.
Not to fit long lawsuit. It's around lawsuit. 16
Yes, yes.
What part might be 80? What
244.
lawsuit?
There's no point going through everything.
Lordship, he's correct that way because in respect of the response number 3, the finding is starts from page 244, but I have addressed this honorable court from page 231 because to give the impression how the labor court came to this finding from the
No, no, you come to this. We'll
lordship,
see.
some
We'll give you.
part may be important because the how the landed labor court treated the inquiry report in respect of the workmen, that lordship may require to
Yes. But
may read lot. It will
can the labor court go into the evidence?
that only for this reason what happened lordship. From the award lordship will find that I have read the inquiry report. I've shown this honorable court that how the tokens were issued, how he replied, all the fairness were there.
All the procedural
No question on that. Now, whether the labor court can go to the evidence, lordship literally what are the submitting with due respect, lordship landed labor court has cleared the inquiry report. Peace in peace, lordship. That's the reason, lordship, and this is before this honorable court. He even put questions on the finding of the inquiry officer. Because if two views are possible, management has some liberty to proceed. So management has the right to against whom the management can proceed. The labor court went to such an extent that why he no proceeding is him, why only it is him, this is sufficient enough to hold that charges are wrong. To that extent, labor court is done. Whether because lordship knows lordship, once the labor court comes to the finding that inquiries fairness was there, then only 11A comes in. 11A is the quantum of the punishment. How much, whether it is disproportionate or not. Even lordship, if a lordship takes up the Industrial Dispute Act 11A, section 11 capital A,
Yes.
lordship. 11A, powers of the labor court, tribunal and national tribunal to give appropriate relief in case of discharge or dismissal of workmen. Where an industrial dispute relating to discharge or dismissal of a workman has been referred to a labor court, tribunal or national tribunal for adjudication, and in the course of adjudication proceeding, the labor court, tribunal or national tribunal, as the case may be, is satisfied that the order of discharge or dismissal was not justified, it may set aside the order of discharge or dismissal and direct reinstatement of the workman on such terms and conditions, if any, as it thinks fit, and give such other relief to the workman, including award of any lesser punishment in lieu of discharge, dismissal, as circumstances of the case may require. Provided that in any proceeding under section, labor court, tribunal, national tribunal, as the case may be, shall rely on the materials on record and shall not take any fresh evidence in relation to the matter. More so, lordship, here, if lordship will go, if we see lordship, the matter regarding compulsory retirement has not been incorporated here, only in respect of dismissal and discharge. And lordship, labor solution being beneficial, if we accept that also that compulsory retirement being severance of service, if we include that also, then also lordship, labor court may not reappreciate the evidence. The labor court cannot sit up appeal. My humble submission on the sit on appeal on the order or
With
inquiry.
the merits of the case.
Lordship. Once labor court comes to finding the inquiry was fair, then nothing, only a disproportionality of the punishment. That much lordship. Whether this lordship, from the evidence, okay, I'll show people in all the court that at least one fact is clear, Lordship, that I have annexed the evidence also and the cross-examination done by the delinquent employee also. The action of the employee on 7/10/2002 by entering into the meeting room of the committee is true. There was no cross-examination to the respect. That is Lordship. He, along with others, had entered into the meeting room of the officers and demanded revocation of suspension of 2-3 employees without permission. That part is there, Lordship. From the evidence, Lordship will find. If I read the evidence part also, I can show Lordship. I've typed the evidence part, Lordship.
Let us go to this. What? What are it say?
Lordship, I'll go to there. But page 234.
234.
Lordship. The case has arisen on receipt of the order reference number such and such by 9/5/14.
Are we reading everything?
No, Lordship, this part I may skip, Lordship. Only Lordship, the page 35, Mr. LP Sharma here, Lordship. My planet senior who is no more, Lordship.
Huh?
My senior argued the case, he is no more today, Lordship. Mr. LP Sharma is. So he argued the case in the labor court. What happened? Here, Lordship, my LP Sharma argued that regarding that compulsory retirement not being incorporated in section 11A, and labor court has came to the finding that being severance in service, I can go into this law. So I'll be reading from page 239.
Yes.
Lordship, keeping Lordship 1 to 3rd paragraph I would read, Lordship.
Yes.
This court, Lordship.
Yes.
This court has the power to judge the inquiry report and also quantum of punishment if the inquiry report is found acceptable. It was held in Workman versus Firestone that Robert reported in Sajastar. 13. The above position has been completely changed by section 11A. It is now obligatory on an employer to hold proper domestic inquiry in which all material evidence will have to be adduced. When a dispute is referred for rectification and it is found that a domestic inquiry conducted by the management is defective, or if it is found that no domestic inquiry at all has been conducted, the order of discharge or termination passed by the employer becomes without anything more unjustified, and the labor tribunal has no option but to direct the bidding statement of the workman concerned, as his discharge or dismissal is illegal. Even in cases where a domestic inquiry has been held and the finding of misconduct recorded, the labor tribunal have now full powers and jurisdiction to reappreciate the evidence and to satisfy themselves whether the evidence justify the finding of misconduct. Even if the inquiry proceedings are held to be proper and the finding of misconduct is also accepted, the tribunal has now power to consider whether the punishment of dismissal or discharge was necessary for the types of misconduct of which the workman is found guilty. In such circumstances, the tribunal can also give any other relief to the workman, including the imposing of a lesser punishment. In case where an employer had not conducted any inquiry or when the inquiry conducted by him is held to be effective, the employer will not be given any opportunity to produce evidence before the labor tribunal for justifying action. Various decisions of this court have emphasized that there is an obligation on the part of the employer to hold a proper inquiry before dismissing or discharging a workman. And it has also been stated that inquiry should be conformed to certain well-defined principles.
Okay, tell me something. Does the labor tribunal have the power to reappraise the evidence?
Lordship,
What does the law say?
law says, Lordship, that labor tribunal, I've got the person also, labor tribunal cannot take up appeals over the inquiry. Where is that clause? Form 28 note. Okay, para 17, 17, 20, and 21.
17, 20, and
21.
21.
Yes, narrator. After going through the order of the industrial tribunal, we are of the opinion that industrial tribunal has interfered with the finding recorded by the domestic tribunal as if it was the appellate tribunal. There was evidence present on record regarding incident, riotous and disorderly behavior of the respondent towards his superior. The management witnesses who were present at the scene of occurrence have unequivocally disposed about the misbehavior of the respondent towards his superior. Their evidence has been discarded by the tribunal by observing that in the absence of independent evidence, the statement of the workmen who were present at the scene of occurrence could not be believed. The industrial tribunal failed in error in discarding the evidence produced by the management only because the independent witnesses were not produced. Paragraph 20 law. The tribunal has set aside the report of the inquiry officer and the order of dismissal passed by the punishing authority by observing that the charges against the respondents were not proved beyond reasonable doubt. It has been repeatedly held by this court that the acquittal in the criminal case would not operate as a bar for drawing up the disciplinary proceeding against the delinquent.
That's got nothing to do with this.
Okay.
The law here says that criminal proceedings is no bar
No, but
for a
nothing. No,
That's not the issue. The issue is whether the tribunal can be a patient evidence.
no, that's also there. No.
Where is that? What about
Lordship, this lordship, I have only one case. I'll be reading it and looking because you are not the in the instant case, this is reported in 2021 law. In the instant case, after we have gone through the record, we find that tribunal has converted itself into a court of appeal as an appellate authority and exceeded its jurisdiction while appreciating the finding recorded in the course of domestic inquiry and tested on the board principle of charge to be proved beyond reasonable doubt, which is a test in the criminal justice system, and has completely forgotten the fact that a domestic inquiry is to be tested on the principle of preponderance of probability, and if a piece of evidence is on record which could support the charge which has been leveled against the delinquent, unless it is per se unsustainable or perverse, ordinarily it is not to be interpreted by the tribunal, more so when the domestic inquiry has been held to be fair and proper. And in our view, tribunal has completely overlooked and exceeded its jurisdiction while interfering with the finding recorded during the course of inquiry, in furtherance of which the respondent was dismissed from service, and the High Court has also committed many such errors while passing the judgment.
which paragraph?
Paragraph 18 law.
18. But
Now, Lordship, the Firestone case, which was the Firestone case, which was relied upon by the Lanet Labor Court. While passing the award, Lordship, the Lanet Labor Court at page 239, Lordship, has relied upon para 13 of the case, Lordship.
this parasite is
Lordship, my humble submission, Lordship, the, paragraph 13 of this judgment is not the Lordship ratio passed by the learned Honorable Supreme Court because it was the submission made by Honorable Council. If we read paragraph 14, Lordship will find that
Ah.
the above is the line of argument adopted by Mr. Desno.
Yes.
Lordship. But paragraph 13 was the submission made by Lanet Council of there. That's what is there.
Correct. That's what I was fighting. It's quite funny.
Lordship,
It becomes like a fully, like a photo of a piece.
Lordship, that's but
Like in a civil,
Lordship,
civil piece.
but Lordship, I was fairly submitting Lordship. Lordship may peruse Lordship, paragraph 36 and 37 Lordship of the section. Some sense there is there also. Paragraph number Lordship 36 and 37.
Yes.
May I read Lordship? We'll first consider cases where an employer has held a proper and valid domestic inquiry before pursuing the order of punishment. Previously, the tribunal had no power to interfere with its findings of misconduct recorded in the domestic inquiry unless one or other infirmities pointed out by this court in certain such cases existed. The conduct of disciplinary proceedings and the punishment to be imposed were all considered to be a managerial function with which tribunal had no power to interfere unless the finding was perverse or punishment was so harsh as to lead to an inference of victimization or unfair labor practice. The position in our view has now been changed by section 11A. The word in the course of rectification proceeding, the tribunal is satisfied that the order of discharge or dismissal was not justified, clearly indicates that tribunal is now clothed with the power to reprise the evidence in the domestic inquiry and satisfy itself whether the said evidence relied on by the employer establishes the misconduct alleged against the workman. What was originally a plausible conclusion that could be drawn by an employer from the evidence has now given place to a satisfaction being arrived at by the tribunal that the finding of misconduct is correct. The limitation imposed on the power of the tribunal by the decision of Indian Iron and Steel can no longer be invoked by the employer. The tribunal is now at liberty to consider not only whether the finding of the misconduct recorded by an employer is correct, but also to differ from the state finding if a proper case is made out. What was once largely in the realm of the satisfaction of the employer has ceased to be so, and now it is the satisfaction of the tribunal that finally decides the matter. This was,
Because they can be a plain evidence.
but where per se perverse, the workman has to make out a case per se perverse law. But I have annexed the proceeding also. Lordship will find that as regards the incident of at least that 7-10-2002 incident, there was no cross-examination, and that incident has been proved in the inquiry report.
And the inquiry officer held that it was not true.
No, inquiry officer held that's true. But
Which charge?
Charge number 4, Lord,
Partly.
partly Lordship. Because its presence was proved there. Lord. And the landed labor was a reverse.
What about 1 and 2? Did it reverse 1 and 2 also?
No. So there's a Lordship entirely. Lordship. Labor was entirely of what I'm submitting regarding the charge number 4, 1, 2, and 4. My submission is his presence on 7/10/2002 is proof. Now 1, 2, and 4 all comes along.
Seven ten 2004.
Two lots. May I read the award now?
How long will you take?
Look, if,
This is your figure, one hour.
look, if, 10 pages award,
Huh?
10 page award.
You don't have to read it. Everything is separate.
Lordship.
But this will never end the case.
The award process. Lordship, in fact, in that case, Lordship, I am reading the award first in as regard him only, Lordship. Page 244, Lordship.
We'll take it up at two.
Oh, I'm sorry.
You please try to condense your submission.
Lord.
It's so. That is so much time. That is a simple.
Lordship, I am going to the award, Lordship.
Ah.
Award in respect of the present workman, Lordship. Page 244. Lordship.
Yes. Yes.
I'm reading from third paragraph, workman. Workman LDA Sri Vidyadhar Nath, respondent number 3, Lordship, was put under suspension by
No, please
order.
don't read all this. This is not. This is the facts of the case. Go to the operative portion
No, only
or
two
the
pages.
findings.
Only 2 pages. Only 2 pages.
Yes.
This is in respect of this workman only. Workman LDS Sri Vidyadhar was put under suspension by order dated 23/6/2005, but charge sheet against him was furnished to him by order dated 5/11/05. As per the statement, allegation annexed to the charge sheet, Exhibit 3, as many as 8 allegations were brought. The inquiry officer in his inquiry report brought the charge into 10 different heads. They are insubordination, violation of office discipline, unbecoming an employees committee, threatening the superior officer, threatening the executive officer of committee, misbehaving with precedent, leaving the office without permission, obstructing within workers, and threatening with their consequences, riotous behavior. But in the last part of the inquiry report, inquiry officer observed that charge number 1, 2, partly charge number 4 are proved against the delinquent employees. The inquiry officer was specific while observing that charge number 5, 6, 7, and 8 were not proved. The charge number 1, as per the charge sheet, was that workman was put under suspension by order dated 23/6/05, and one student Nath, peon of the committee, was deputed to hand over the order of suspension to him, but he refused to accept the suspension order. Thus, the charge of insubordination, violation of office discipline, and unbecoming of an employee of the committee are leveled against him. Before the inquiry officer, as many as 4 witnesses were examined. They are Basanta Kumar Saraswati, Priyasaki Devi, and Sri Chitra Mahanta and Sri Sujata Kumar Sekia. Allegations against the workman was that he did not accept the suspension order issued against him. One office peon student Nath was deputed to hand over the suspension order to the workman. As per the charge, the workman refused to accept the suspension order from student Nath. It is surprising to note that the inquiry officer, without examining the peon student Nath, held the workman guilty of refusing an office order. Thus, the finding of the inquiry officer is not a legal finding. Hence, finding is not acceptable in the eyes of the.
Without examining the peon, Surendra.
Fair enough. It
So
was.
this is correct. What is wrong with this?
Lordship, I am going further. Charge number 2, which inquiry officer found proof, was that the workman refused to accept the suspension order from one peon Jagdish Gogoi. And thereafter, the suspension order was sent to him through registered post. But the state letter was returned back with an endorsement refused. To prove the charge number 2, the inquiry officer did not examine the peon Jagdish Gogoi as well as the staff of the postal department. Moreover, the track report of the person was not called for from the postal department. Therefore, this charge cannot be said to be proved in the eyes of law. The charge number 4, claim against the workman, is stated to have been partly proved. The charge number 4 was that on 7/10/2002 at 12 noon, the workman and some other person entered into the office chamber of the Mantri and demanded revocation of suspension order of Bimal Kumar Nath, Shailen Sharma, Dimbeswar Bora. It is also alleged that they confined the officials and tried to attack them. But in para 2 of the inquiry officer was contradictory opinion. In the first part of the paragraph, he stated that from the evidence of PW 1, 2, 3, and 4, it is seen that Mantri and other officers were confined on 7/10/2002. But in the second part of the same paragraph, he stated that he was with the agreement of submission and there was no incident on 7/10/02. In para 4 of the inquiry report, the inquiry officer held that workman guilty partly under charge on the ground that though the workman did not misbehave to any officer on 7/10/02, but he was member of the unruly workers. It has come in the evidence of Mantri Sri Basanta Kumar Kakoti in the inquiry proceeding against the workman Sri Vidyadhar Nath regarding the incident that occurred on 7/10/02. No complaint was lodged before the police. It is seen that before issue of suspension order dated 23/6/2005, no charge sheet or shlokas was issued to the workman. So, Lordship,
No requirement.
no requirement, Lordship, then the Lordship, no requirement. Thus, it is seen that suspension order was issued against the workman without informing any guilt to him. Lordship, this is the finding, Lordship. There is no explanation in the evidence of any
I want to see this. Page 245, the last paragraph.
last paragraph, Lordship. In the inquiry report, Lordship.
Yes, but
Lo-
para 2 and this
Lordship,
para
okay,
2 of the
I'll go
inquiry.
to that, Lord.
See?
I'll go to that. Lord.
Page 146 is the inquiry.
Yes, yes, Lordship. Lordship will find that at page 150, Lord.
One 150.
150, Lord. Lordship. Second paragraph. It is also a fact that the charge sheeted employee refused to receive the registered letter bearing suspension order to the concerned workman, and as a result of which the management had to publish the case suspension order in the Assamia cover on 15th of July 2005. In the written statement also, he admitted that the registered letter was sent to him in his office address. I cannot agree with the suspension submission made by the
Just a minute. And from the evidence that is here, this is, so what else? I don't understand this 245.
Lordship, what happened?
No,
The London Labour Court tried to interpret this part that the inquiry report officer has given contradictory view.
That's one.
I think, Lordship, maybe, Lordship, my understanding, Lordship, in the last line of page 150, that I think it ought to have been the workman, maybe, because if we read
The management could
workman-
not adduce any evidence to several charge leveled against the tax-treated employees. In cross-examination, this one.
Lordship, that part, Lordship, as such, I am agreeing with the submission and cross-examination of the management witness that there was no incident, may not be, Lordship, because
Where are you reading?
Lordship, page 150, Lordship.
Yes, where?
So I
Which line?
Lordship, I am reading the last part because
Last part means which line?
Lordship,
Last line, second last line, third last line, which line?
second last line, and as such,
There is no and as such. Okay, that is in the second paragraph of the second line.
Lordship,
There is a difference between Mr. Counsel. You see, this is the last line of this page.
Lordship, no.
Last line of this page is envelope.
No,
Yes,
no, we are
So this-
discussing that paragraph, Lordship, that contradictory
So
paragraph.
when I ask you if it's the last line of that page,
Lordship,
I didn't ask you if it's the
I'm
last
sorry.
line of which paragraph.
Lordship, I was thinking that that paragraph discussed by the labor code, Lordship. Let us read this entire paragraph again, Lordship.
No. Just a minute. In the written statement, it also admitted that the registered letter was sent to him. Okay. Um, so the IO had said that he did not agree with the delinquent employee submission. That had there been any incident, management would have reported the matter to the
Lord.
police. So it was in that context
That
that this
context,
came.
if we read the
Yes,
entire
twisted it.
Lordship, the labor code has taken the interpretation. That labor. Yes,
Okay,
Lord.
and the labor court also has not considered the written statement made by the respondent number 3,
Lordship,
where he has admitted to this suspension order
yes,
being sent
yes,
by registered post
yes, to him.
to him
He has admitted that part, Lordship.
in the written statement.
Yes, Lordship. Even in examination.
Let me see the written statement of defense page. Reply, it is 102.
102, I think, Lordship. Give me a minute, Lordship. Yes. Yes, Lordship. Lordship will find it at page 102, Lordship.
It's his own submission.
Lordship, reply to the Chopper's, Lordship.
Huh?
Reply to the Chopper's, Lordship.
Yes. Which paragraph?
Lordship, I think paragraph number 2, the allegation that I refuse to accept the suspension order sent to me by registered post and same is returned back with the address review is not correct. The postman did not come to deliver the letter to me, but surprisingly, he returned the letter with such an endorsement. I never met the postman, and as such, there cannot be any question of refusing any registered letter.
No, not this.
Number 3, my.
Number 3 Lordship, is like a 71002. That with regard to allegation number 4 is that I did not enter the office.
No, this is a different.
This
You
is a-
you
as
can
regard to
deny,
allegation-
but if there is an eyewitness, you see, no murderer or thief will say that I committed it.
Yes, Lord.
But they are convicted on the basis of an eyewitness or someone. Now, in your case, that high degree of proof is not required.
Yes.
Okay, because the Mantri ji himself is a witness.
4 witnesses, Lordship, not
Huh?
the month. 4 witnesses.
I know.
The monthly
So
Lord.
all 4 of them were there.
All of them were there, and I have enacted the evidence also.
Okay, but 1 and 2 does not seem to be proven.
No, there's the reason also for the Lordship, from the beginning, Lordship, I'm saying that 71002, that is.
That is true.
And unruly behavior, he was present with the unruly mob, that part is there. And that is, Lordship, my humble servant is good enough for even for dismissal, Lordship.
That's all. Anything else?
No, Lordship, only one judgment, one more judgment I want to rely, Lordship. Lordship, 2018 1 SCC 285.
Para?
Para, Lordship, I'll be reading para 17, 17, Lordship. 17, 18, 19. And Lordship, 28, 29. May I read, Lordship?
Yes.
To begin, 17, Lordship. To begin with, when we examine the legality and the correctness of the award of the labor code, we are of the considered opinion that the labor court having held, and indeed rightly, that the department inquiry conducted by the appellant was legal and proper, committed an error in holding that the department inquiry
This is a different issue, Mr. Counsel.
lordship,
This is with regard to a criminal court passing an order.
how to appreciate lordship, para 18 lordship, in
Huh.
our opinion,
Huh.
once labor court upheld the department inquiry as being legal and proper, then the only question that survived for consideration before the labor court was whether the punishment of dismissal imposed by the appellant to the quantum was legal and proper, or it
No,
required.
no, Mr. Counsel,
That's what-
but you see, this case does not fit in the fact of this case,
Lordship,
because as per the finding of the tribunal,
lordship,
labor court, the finding made by the inquiry officer was wrong.
wrong, lordship,
Ah,
but.
But that is not the case. Out here, in this case,
He has not questioned the proceeding, lordship, but as there are fairness, lordship, because all the procedures are
Mr.
followed,
Counsel, see, there are two things.
lordship.
One is you have got to see whether there's some procedural irregularity. Even if there is no procedural irregularity, if if the labor court can reappreciate the evidence, then what is wrong? It doesn't mean
Yeah.
now do you say that the labor court cannot reappreciate evidence?
As per Firestone lordship,
Huh? As
as
per
per Firestone lordship, 73,
it can, then
given some,
Then?
if per se perverse, if the same is per se perverse, then only lordship, it can be
this
done.
has got no meaning. Then next para what?
Lordship, I've given 18 lordships and 19 lordships. In other words, labor court should have then confined.
No,
this
no,
inquiry
no.
to examine.
You see, you show me a law that says that the labor court cannot reappreciate evidence.
No, lordship. I
You don't
cannot
have.
say. Because
Then-
what
Then
happens,
this judgment is not applicable to the facts of this case because there are two aspects. Now, this judgment only speaks of whether the procedure has been followed or not. So this judgment says that once the procedure has been followed, only two things are to be seen, whether punishment or
dismissal,
or dismissal.
lordship. No,
The
but
punishment
no
or
question or no.
disproportionate.
Lordship.
So there's only two. Now, this case did not look into the question of reappreciation of evidence.
Lord.
So in this case, it had the reappreciation of evidence.
Only two things are there, lordship. Only 73 that Firestone, which has been relied by the learned labor court. There, as per that lordship, labor court can reappreciate
Correct.
the inquiry report.
Correct.
If per se pervert, one thing is there, and second,
Where does it say per se perverse?
lordship, and 21 judgment.
Where does it say per se
Lordship,
perverse?
page, para 36 later. Page, lordship, it will be 830, paragraph number 36.
Oh, you have not given me a copy.
I've given the copy. Right.
You have given me.
I've given note.
Where? Where does
Para
it say?
36 law,
Para?
36 law.
36 here.
The word in the tribunal, last three lines of para 36 law, last three lines.
Yes.
The tribunal is now at liberty to consider not only whether the finding of misconduct recorded by an employer is correct, but also also to differ from such finding if a proper case is made out. If a proper case is made out, what was once legally in the realm of satisfaction of the
So where
employer-
is the word perverse?
Lordship, that person, if case is made out, lordship.
Naturally.
Lordship, that is the lordship.
Okay, I heard you. Yes. That's all.
That's all lordship. Only in case of 21 judgment I placed before this honorable court that there it is stated labor court may not sit in the court.
Now, what did the labor court say in the final judgment, in the final
Final part, lordship,
yes.
final part, lordship.
page? What does it say?
Therefore, lordship, page 250, lordship,
2?
250, lordship.
50. Yeah. 250?
Lordship, 250, lordship, the finding, lordship. What the ultimately labor court was.
Where is the finding?
Lordship, finding is since the suspension and compulsory retirement are found to be illegal and deserve, they deserve
Page.
page 250, lordship, 250, lordship.
Okay.
The finding is last part, lordship, since. Since the suspension and compulsory retirement are found to be illegal they deserve full back wages from the date of suspension till the date of retirement. They also deserve full retirement benefit as if they were in service from the date of suspension till date of retirement. Some lordship, in fact, in the award lordship, as regards the response number 3, the present workman before the honorable court, some more findings were there, lordship.
Yes, but
My lord, regarding that charge number 4, kindly come to page 151.
yes,
Para 4, my lord.
para 4, yes.
That further from the evidence of the witnesses of the management, it is crystal clear that the charge sheeted employee was present along with others on 7/10/2002 in the office chamber of the Mantri when the EC meeting was going on. But all the witnesses of the management specifically deposed that Sri Vidyadhar Nath did not misbehave any of them. But however, he entered without permission along with others to the office chamber of the Mantri on 7/10/2002, and thus the management has been able to do so and so. So, my lord, this is very important.
That further from the evidence of the witnesses of the management, it is clear. Was present also in the office of Mantri when he was, but all the before he did not misbehave, but however he entered without along with others to enter the man has the fact that he entered without any permission.
It is there, my lord. But misbehaving part, my lord,
It's not there.
it is on my favor. Inquiry says, my lord, all the witnesses, my lord, had specifically stated that Vidyadhar Nath did not misbehave, and Vidyadhar Nath is before a lordship. So, my lord, all the charges fail, my lord. So, my lord, this order passed by the tribunal suffers no illegality.
Lordship, this is the inquiry report, lordship, and
Inquiry report.
yes, yes. On
Was the management, did the management accept the inquiry report?
lordship, the order is, I've annexed the order, lordship.
No, the inquiry report was accepted or not?
It's taken, lordship. We consider everything, even lordship will find at page 172, lordship.
Yes.
172, lordship.
Yes.
On receipt of, a date is wrong, lordship. That's 11/11.
How does it matter then?
The management, Lord, I am reading the fourth paragraph, the management, it's not the management. The management not being satisfied with the replies furnished by the petitioner not decided to hold domestic inquiry as the intervening person accordingly to Bobita's advocate was appointed inquiry officer, who has duly communicated with the petitioner and duly responsible for Fisherman in an witness or management after closure of evidence. The petitioner ideas also evidence and substance. The inquiry officer submitted his report and finding on 37 The inquiry officer held the management have been able to prove charge number 1, 2, and 4 partly. The report and finding of inquiry was forwarded to delinquent on Iman. The relevant records, including the charge sheet, reply the charge sheet report and the finding of the inquiry officer replied to the report and finding of the inquiry officer by the delinquent official, and the document proved during inquiry were placed before the executive committee. The executive committee, after carefully gone through the relevant records and after careful consideration of the executive committee, was of the opinion that a charges level and proof against Vidyadhar Nath were serious in nature, and no lenient view can be taken against Vidyadhar Nath, as he, along with others, confined the officials. This is the finding of the executive committee. Confined the officials of the committee in a room for more than 8 hours and obstructed the willing workers from working, and shown riotous behavior toward the higher officials and threatened the superior officers. The executive committee decided that for the interest of the committee, the services of the Vidyadhar Nath should not be retained in the committee any further, and he be compulsorily retired from the service of the committee, provided under chapter such and such or such and such, chapter such and such. The Vidyadhar Nath be and is hereby compulsorily retired from the service of the committee with effect of 4309. Further, the executive committee also.
Where is the charge frame regarding that entering into the office?
My lordship. Josh, look,
My lord, page number 91,
91.
point number 4. That's number 4. Here it says that he, along with others, threatened the officers, members of the executive committee.
But that is not stated by the IO.
No, that is not there.
Inquiry officer does not say that at all.
No, no. That finding is not there. That charge is not.
That is not true. You entered, that's all right. But then you entered, but then you did not do anything.
No, no, it will. It was
He-
entry was
There-
not there.
is there any finding that he entered forcefully without, huh?
Without permission, that is enough.
Where does it say that? Without
No.
permission?
Lordship,
Where does it say without permission?
Lordship, in that case, Lordship, I'll be reading the evidence deduced in the inquiry report, Lord, in the report. Lordship, it's the 104 law. The,
104.
104. Small evidence of Lordship.
104. Yes, what does it say?
104 Lordship is a type copy, Lord.
Yes.
I have annexed the original also.
Yes, yes.
These were the witnesses who adduced.
Yes, read.
My name, Lordship, start from, my name is Basantagam Kavati, son of the I was the Mantri of the Assam Rashtra Forest Committee since 2006. Now I know Sri Vidyadhanath, who was LDA. He was placed on the suspension on suspension date and my signature. Therefore, he was issued to notice on Iman. Incorporating 8 charges and based on the, he was furnished with a list of documents, Lordship. As Vidyadhanath refused to receive the suspension order, same as published in Rashtra Khabar on suspension.
I'm not on that. Where's the
On
entry?
1702.
Yes.
On 1702, when the executive committee meeting was going on, Vidyadhanath and other entered my room and demanded to revoke the suspension order of the Bimal Nath, Silin Sharma and Dipesh Bora and confine the member of the executive committee in the room and used unpolitely words and closed the main gate and tried to attack the official of the committee. Though Vidyadhanath accompanied the group, he did not utter any word against me as well as towards a committee member. Though Vidyadhanath actively associated with such and such. Now cross Lordship. He was cross is page 106 Lordship. Regarding this part only, he was placed under suspension such and such. He was actively associated such and such. I do not remember whether any resolution was taken by the executive committee on 1702 for revoking the suspension order of Bimal Kumar. I do not remember whether Shokas notice etc. were held for the incident on 1702. And now Lordship, MW number 2, page 107. Only as they 710 Lordship. I was administrative officer during 2002 of the committee. I know Vidyadhanath, he was an employee of some examination branch on 1702. When our executive meeting was going on in the office room of our Mantri, suddenly Vidyadhanath and others entered the office.
This is the evidence, but this is not the finding
No, Lordship.
of the inquiry
These are
officer.
the findings, these are the evidence, Lordship, from where the findings came, Lordship. If Lordship appreciate
What finding came? The finding
Lordship,
of the inquiry officer, he does not say anywhere that they were confined in their room.
Lordship.
Where does he say that?
Oh, but
Or that this respond number 3 had told them to revoke the show cause notice or the suspension order.
Lordship,
Where is that?
these are the evidences which these witnesses were cross-examined by.
Can this court, this writ petition,
Lordship,
can this
yes,
court
I
go
appreciate
into
that,
those?
Lordship, yes.
Huh?
Yes, Lordship. Due to this reason, what I am saying, Lordship, as the Labour Court entered into the entire event, the inquiry report and the evidences, the learned Labour Court ought to have considered the evidence adduced before the inquiry proceeding also to appreciate the outcome of the report. The Labour Court has not done this, Lordship. That is my submission,
Mr. Counsel, neither did the inquiry officer in the first instance.
Lordship.
Neither did the inquiry officer in the first instance, dwell upon this subject with regard to whether they had asked for revocation of the suspension order. So the witnesses have said it. Inquiry officer did not say it.
Did not say that.
Then, and you accepted the inquiry report.
Accepting the inquiry report, Lordship, we have imposed the punishment of compulsory retirement. Upon the
Mr. Counsel, it is very simple. No point discussing. Yes, I've heard enough. Right. Anything, madam? Anything, any judgment, any citation, nothing? No? You're not there. Right. Heard, Mr.
F. Chakraborty.
Eh?
Chakraborty.
Have you given your wakalat number?
Lordship, my LP Sharma's name is there, Lordship. He is no more, Lordship. He expired.
Oh, that may be, but where is your wakalat number? Yes, Chakrabarti.
No.
Heard Mr. Chakrabarti. Learned counsel for the writ petition. Bracket management. Also heard Mr.
F. Khan.
F. Khan. Learned counsel for the
That's point number 3.
point number. No one appears for the, no, Miss, you just appears for respond number 1. No one appears for the respond number 2 and 4.
2 and
Good stuff. At the outset, the counsel for the petitioner submit that the respondent number 2 died during the pendency of the case and that the legal heirs of the respondent number 2 have accepted the impugned order dated 4/3/2009 issued by the management against the respondent number 2, 3 and 4.
That is not impugned by that.
no, no, no.
Impugned in the award by you,
That impugned order passed, the order
that is impugned till now. Because that is still an issue.
Yes.
Good stuff. The petitioner's counsel also submit that during the proceedings of this case, the respondent number 4 has also accepted the impugned order dated 4/3/2009 issued by the management, comma, by which the services where is the order against the 2 and 4? Huh?
Lordship, as regards respondent number 4, Lordship, it is a page 231. Respondent number 4 is, Lordship, 231. And in respect of respondent number, Lordship,
By which they have been compulsorily retired from service. Next. The case in brief is that the petitioner, the case in brief is that the respondent number 2, 3 and 4 were workmen. The case of the petitioner in brief is that the case of the respondent number 3 is that he is a workman. There's a workman, comma, who was placed under suspension by order dated 23/6/2005 Correct. Okay. Show cause notice dated 5/11/2005 was issued to the respondent number 6. You have typed this copy, you can't read it fully also. Yes, where do I get the charge? Give me the charge. I can't read it.
Lordship, page 91.
I've got page 91. Give me a better copy.
Okay. Taken to the checkbook.
Why don't you type it out?
Similar item. No. Also,
No, no, whatever I said. Asking him to submit his written statement of defense against the 8 charges that were made against him, some of which are as follows. Page 91, you take whatever you can. I put it in red so that you understand. 1, 2, 3, 4, 5, 6, 7. No, 5 is 5 is here. 5, 6, 7, 8. Okay. 191, 92. The petitioner submitted the point number 3 submitted his reply to the state denying the charges made against. So thereafter, a disciplinary proceeding was not. Thereafter, what? A departmental proceeding.
no, the domestic inquiry.
The domestic inquiry was initiated against the petitioner. And the inquiry officer gave his report dated 13/7/2008. By coming to a finding that charge number 5678 were not proved against the petition. What about 3?
Because nothing else will state only 1 and 2.
First off, the inquiry officer found that charges 1 and 2 were proved against the petition, and charge number 4 was partly proved against the petition. However, no decision was made by the inquiry officer against charge number 6. Next one. The inquiry report was thereafter sent to that's point number 6. Requesting him to submit a representation against the city. Consequent to the above, comma, the impugn order dated 4/3/2009 was issued by the management, by the risk petition compulsory retiring the petition, that is point number 6, for Mr. Being agreed by the state, the petitioner. What did you do? Agreed by the order, what did you do?
Lordship, they raised, Lordship, reference number 2, 3 and 4 raised industrial dispute, Lordship. And subsequent to that industrial dispute, Lordship, page 233, Lordship. The matter was referred to the labor court for adjudication.
There is point number 3.
Raised industrial dispute.
Raise an industrial dispute. With the government of Assam.
Sure.
And thereafter, by notification dated 9/5/2014. The industrial dispute was referred to the Industrial Tribunal Guwahati. For adjudication as per the following schedule. Number 1 and 2, page 233. The reference there in the before the Industrial Tribunal Assam, Guwahati, our reference is number 1 of 2006 was registered. Against the reference against the industrial dispute raised by the point number 2. The reference case number 1 of 2006 was thereafter disposed of by the Industrial Tribunal by award dated 18/9/2017, comma, by which the Industrial Tribunal held that charge number 1 and 2 was not proved against the petition. Charge number 1, 2, and 4 were not proved against the petition. I was just order dated, right? Order dated. I said no. Petitioner said that. Okay. Award date. Then next para. Being agreed by the above, comma, the petitioner has filed the petitioner packet management has filed the present petition, challenging the award dated 18/9/17, passed in reference case number 1 of 2000. Next one. The petitioner counsel submit that the learned tribunal come after re-appreciating the evidence of the re-appreciating the evidence recorded by the witness has come to a finding that charge number 1 and 2 were not true. In respect of the fourth charge, which the tribunal, learned tribunal, also held that the same was not true, he submits that the said finding had been made in view of the erroneous assumption by the learned tribunal that the inquiry report very much. Well, just from prior to that, full stop, full stop. No, no, comma, he submits that. The point number 3 has not entered the monthly room on 7/10/2006. No, no. Please read again from the beginning. Where is that evidence that regarding this, that two different understanding?
Lordship, at page Lordship 149. The inquiry report or the tribunal finding? Is the main part is
That is the tribunal finding, not
tribunal
the,
finding. And inquiry, what
where is the tribunal finding?
tribunal finding Lordship at page,
Come from one thing to
page 1 to 245 Lordship, 245. 240. Last paragraph, Lordship. The charge number 4.
just read the verse one. Just don't say that. Just say the learned counsel for the petitioner submits that the learned tribunal has misinterpreted the evidence given by PwC, Shri Chitra Mahanta, to come to a finding that the learned to come to a finding that the inquiry officer had stated that there was no incident on 7/10/2002. In the second part of in the paragraph relating to the evidence given by PW 1, 2, 3, and 4, that the Mantri and other officers were confined to their room on 7/10/2000. He submits that the presence of the respondent number 6 in the Mantri's room on 7/10/2002 was proof, and as such, the learned tribunal could not have come to a finding that the charge number 4 was not proved, was not partly proved. But then, can you punish for just coming into the room compulsory retirement?
Lordship, unruly behavior, Lordship, because he was the part of this unruly mob, Lordship. Perhaps, Lordship, he has not uttered his words, but if we excuse him, Lordship, that will be practicing because they have the entering the room is a proof, Lordship, and he was part of that unruly move. Mere he not speaking anything will not exonerate him, Lordship. Otherwise, he ought to have been dismissed, Lordship. Only due to this fact, he has been given lesser punishment. And one more thing, Lordship. One more, what I'll be submitting that the finding of the learned tribunal in perverse, Lordship, because in page 246, Lordship, will find as regards this document, page 246, Lordship. Thus, I'm reading from the middle paragraph. Thus, it is not been proved that presence of workmen Sri Vidyadharnath on 7/10/2002 in the midst of other workmen, Lordship. That was the finding by the learned tribunal because the evidence speaks otherwise, Lordship. Have been shown to
Enough, Mr. Counsel, I am passing the judgment.
Lordship. That part, Lordship, I have just shown to you, Lordship.
This is our no use. Yes, sir. He submits that in view of that, even though the respondent number 3 may not have uttered any word inside the room of the monthly comma, the very fact that the respondent number 3 had entered the room with others without permission shows that the shows that the learned tribunal was wrong in his finding that the respondent number 3 did not enter the on what date is that 7/10/2000. He submits that in terms of the judgment of the Supreme Court in the case of uh, in the case of Standard Chartered Bank versus R.C. Srivastava, AIR 2021, Supreme Court 4879, comma, in a domestic inquiry charge has to be proved on the principles of preponderance of probability. And if a piece of evidence is on record which could support the charge which has been leveled against the delinquent, comma, unless it is per se unsustainable of purpose, comma, ordinarily is not to be interfered with by the tribunal, comma, more so when the domestic inquiry has been held to be fair and proper. He further submits that in terms of the judgment of the Supreme Court in management of Bharat Heavy Electricals Limited versus M Money, 2018 1 SEC 285. The Supreme Court has held that once the Labour Court upheld the departmental inquiry as being legal and proper, comma, then the only question that survives for consideration was whether the punishment of dismissal was legal and proper or required any interference in its conduct. Yes, sir. He submits that in the case of the workman of MS Firestone Tire and Rubber Company of India Private Limited versus the management and others, 1973, 1 SCC 816. The Supreme Court has held that that then the tribunal is loaded with the power to reappraise evidence, reappraise the evidence in the domestic inquiry and satisfy itself whether the said evidence relied upon by an employer establishes a misconduct alleged against the workman. Okay. The petitioner started, now the petitioner started something that as there was no procedural impropriety in the domestic inquiry conducted against the petition, against the respondent. The Learned Tribunal could not have interfered with the findings of the domestic. They accordingly says that the impugned judgment and order, the impugned order dated 18/9/17 should be set to stop. Next part. Mr.
F one.
F. Part. The learned counsel for the point number 3. Subject. That there is no infirmity in the finding of the learned tribunal that charges 1 and 2 were not proved. Inasmuch as the crucial witnesses to prove the charges had not been examined in the domestic case. In respect of the fourth charge, he submits that the inquiry report dated 13/7/2008 has clearly shown that though the respondent number 3 was present along with others on 7/10/2002 in the office chamber of the monthly when the EC meeting was going on, comma, the respondent number 3 did not misbehave with any of them, comma, though he entered the office without permission along with us. So it is the fact that he entered without permission.
We are denying, my lord, but even, my lord, for the sake of argument, assuming but not admitting, I entered. Then also, my lord, no misbehavior from his part. A person may be a part of one assembly, but that person should have that mens rea.
But then you entered without permission.
Charge number 4, my lord, if I read charge 4, there is no charge frame against me that I entered forcefully or without permission. These words are not there,
Not there.
not framed in the charge.
It is only that you misbehaved.
That also not there, my lord.
That's
These previous part,
that's fine.
it has to be
he
the charge.
submits. If he submits that the charge framed against the petitioner as charge number 4. No, he submits that the fourth charge framed against the petitioner does not make any mention of the respondent number 6 entering the office of the monthly on 7/10/2000 without permission. As such, though the petitioner entered the office of the monthly on 7/10/2000, you entered, no? You deny entering.
I did not.
89. Case number 76. Those are petitioner. Uh, what's that? That's what how do you start? Full stop. Assuming that the respondent number 3 had entered the office of the monthly without permission, comma, the fourth charge framed against the respondent number 3 does not make any mention of the respondent number 3 entering the office without permission. We accordingly submit that there being no ground to interfere with the impugned award passed by the learned tribunal, comma, the petition should be dismissed. Next paragraph. I have heard the learned counsels for the party. Charge number 1 pertains to which one is the charge?
Page 91.
Yes, because the first, which is the first charge?
Second, like you are therefore charged with insubordination. That is the charge.
That's the first charge.
So insubordination, violation of office discipline, and unbecoming of an employee of the committee. And contention is one that while you were working as
That
LDA,
is charge number 2.
that's charge number one. No. Your lost
Okay, okay, that is charge number 1. Then which is charge number 2?
Two is lordship that while we were placed under suspension, you refused to receive the aforesaid suspension order from the secretary school. That is true, Lord. And lordship is correct. There is no charge number 3. It appears lordship. That serial number is 4. Next one is 4 lordship. Next is 4 lordship. That is the charge.
Where is 5?
5 is next lordship. Next page 92 lordship.
Okay. Where is 2?
Lordship.
Where is 1?
That when you were placed under suspension.
There is 1.
There is 2 lordship.
And
while
the-
we were working at
One is lordship. That while
Acha,
you were
this is 1. Okay, 1. 1 is here. So 1,
2,
2,
3 is missing.
4.
4.
What have I said? What have I said? 1, 2, and 1, 2, and 4 are reproduced once again. As follows. Huh? Page 191. Okay. The learned tribe is the. Where is the inquiry report?
Inquiry report lordship
146.
146. As regards
The learned tribunal while deciding on while deciding as to whether charge number 1 and 2 has been proven, has held that the has held that as the office peon was not examined to prove that the respondent number 3 had refused to take the suspension order from the said office peon, and that he had refused to accept the suspension order from one peon. What's not just read it again, whatever I said. No, while deciding that charge number 1 had not been proved, had stated that the office peon Soren Nath, who had stated that is point number 3 had refused to accept the suspension order, had not been examined. Similarly, the just one peon Jagdish Das Gogoi, was also not examined to prove that the petitioner had that the respondent number 3 had refused to accept the suspension order, and that no track report of the say that was not. This court, on considering the reasoning of the learned tribunal on the above two charges, does not find any reason to interfere with the set finding of the learned tribunal to publish that. In respect of the third charge, with respect to the fourth charge, framed against the point number 6, comma. The only thing that is proved by the inquiry report is that the respondent number 3 had entered into the room of the mantri on 7/10/2000. The inquiry report the finding of the inquiry officer in the inquiry report relates to the evidence of MW4. MW4, the Kiroda Saikya, comma, who states as follows. Where is that? Para? Page. From the record,
Record load. I have annex load.
page.
In this room, it is a straight here, okay. But nothing, it's not at page 118.
113.
1 1. Thanks. The 11th part, Lordship will find at page 115.
Very well, sir. To state, here is evidence as follows. Page 115. That 115. Okay. It attacked us. The evidence of WW number 1. I think that's the only evidence.
In respect of workman law. Workman only himself,
No. I mean, in respect of that 7/10/2002.
the 710, all the management as stated, Lordship, and there is no cross examination.
No. Where is the management?
Lordship, 115 is the MW4. In Lordship, earlier Lordship, all of their Lordship.
This 114 is the evidence of 1%.
1%, MW4 Lordship. And Lordship, it starts at Lordship, page 104 Lordship.
104.
That is MW1.
104. Yes, sir. The evidence of MW1, P. Basanta Kumar Kakati,
11%, 105.
is as follows. Page 105.
No cross examination. In this, on that point, Lordship.
One zero six till 106. Okay.
MW2 is 107.
Then evidence of MW2, Srimati Priya Sakhi Devi, is as follows. Page 106. Any more?
MW3 is Lordship as 109.
The evidence of MW3, Sri Chitra Mahanta, is as follows. Page 110.
Sure.
Yes.
And 114 is that MW, 113 is MW4. That you have Lordship, your Lordship is there.
So subject para. The finding of the inquiry officer in the inquiry report dated 13/7/08 is to the effect that is to the effect that the respondent number 3 was in the office chamber of the monthly on 7/10/2020 when the EC meeting was going on. So, though he entered without permission along with others in the office chamber of the monthly on 7/10/2020, 2002. Respondent number 3 did not misbehave with any of the persons in the meeting. Anything else? Next. The above clearly goes to show that the appellate that the respondent number 6 was present in the office of the had no had, who had entered the office of the respondent number 6 without permission on 7/20,000. However, the charge framed against the respondent number 6 does not make a mention that the respondent number 3 had entered the office without permission. It only stated that the respondent number 3 had demanded revocation of the suspension order, of a suspension order and others. From failing which he threatened the officer therein. Besides confining them in the setting. Hearing concluded, judgment reversed. It takes too much time. Now,
At least it concluded, my lord, today.
Huh?
Every time this case
Like,
comes up,
we
my
can
lord,
lordship.
it does not reach my
It
lord.
is lordship.
And every day we are here.
Lordship.
in court. And I am appearing pro bono, my lord, for this case.
and so now you have finished at last.
At last, lordship.
Now I have not finished.
Your party will not.